Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people, and people misspelled P-E-O-O-P-L-E? Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Good morning. Good morning. Where's my volume? I moved my volume. That's why I can't find it. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict, and I don't fit in my box again this morning.
He's the guy.
I need to get shorter, or the camera needs to move. Let's move the camera first, because that's easier.
Is that correct?
There, it's like I got shorter. Does that work? Excellent, excellent. All right, we're ready to. Well, I think we're ready. We're close to being ready. Let's move over a tiny bit right there-ish, maybe. So, okay. All right, welcome. It's Monday. Congratulations. We survived the weekend. The ring of fire did not,
that was terrible.
not rain down upon us. There was a little concern amongst those of us who were not very astronomically informed. Let's let the music stop so I can figure out what I'm doing here. Hang on. Wait. Okay. Deep breath. Okay. So now I can fix my audio so I can put it the way it should be. I had a Zoom meeting the other day over the weekend. And I tried to connect. And of course, as soon as I connect, they're like, "Hey, Scott, tell us what you think about," and I start trying to talk, and my audio's all messed up, just completely, because it's set up for the live stream. It's not set up for Zoom. And so I'm talking, and of course I have no idea. And when I'm all done, they say, "By the way, that sounded terrible. We could barely tell what you were saying, and we won't call on you for the rest of the meeting just because, the audio is so bad." And then I adjusted everything in case they did call on me. So it was set up for Zoom, but not for this. Let's see. Okay, now we have that set up. Reset, go. And now I think I can turn this one down. It'll be all right. I have a dilemma. Well, I have several dilemmas. First of all, let's start with owning up to what I messed up. I have no idea who was first in chat. Zero idea who was first in chat. So I'm going to need somebody to own up to it, or somebody to rat them out. But while that's happening, first of all, Krista gifted 5 memberships. That happened before I could click on it, so it's gone forever. No, I just lost another one. Let's see. Let's turn this on right there. Okay, Monday 67. Welcome to the gallery, Blue Courthouse. Thank you very much, Monday 67. Miss Brownstone, good morning. New week. I've been here since Letitia's trial. Just figured out I would post a milestone chat. Love RA. Miss Brownstone, thank you so much. I appreciate that. There was one more I just barely missed. I'm going to see if I can scroll up and at least call it out. Let's see, Karen Scudder, member for 1 month. Karen A. Scudder, member for 1 month. Thank you very much, Karen. I can't put it on the screen because my computer is, it's my fault, but I'll blame it on the computer this morning. And let's see, I think we have a notable birthday. Alicia, welcome to the gallery. Thank you very much. Love the horse picture as well. That's awesome. Thank you very much. And also, let's see who else. We've got Kimbers, Ohio, member for 6 months. Finally in yellow. Yes, Kimbers. Welcome to the Yellow Club. Thanks for everything, RA. Thank you very much, Kimbers, for being here. Wouldn't be the same without you. Happy Monday, by the way. Happy Monday. We have a couple birthdays on the schedule. I think we have 2 birthdays. But first, does anyone? Let me scroll down to the bottom. Who won the internet? First of all, someone was probably telling me. Let's see. I did grow over the weekend, Krista. It's all that fertilizer. It's starting to kick in. Let's see. It's Monday. It feels like a Monday for sure. Okay. Let's see. Ooh, look at this. There's the buffer sound. So that's probably birthday calls. Let's see. Okay, I'm scared to death that any of you would be blind after using a Pop-Tart wrapper. Weatherwatch tried it, and he said, "I tried one Pop-Tart wrapper, but it hurt my eyes, so I switched to 2. I'm like, no! Don't stare at the sun. Don't use my advice for anything. Where's the buffer sound? Hang on. Oh man, I'm so.
For the record, I don't consent to that name.
I'm so far behind. Kelly WV, welcome to the gallery. Thank you very much, Kelly. I think that's West Virginia. Is that right, Kelly? Kelly, West Virginia. I appreciate you becoming a supporter this morning. That is wonderful. Thank you very much. Where's the buffer? Buffer. Let's see. We've got so many birthdays. Where are they at? Okay. Let's see. Kim R. Shells was on Saturday. Courtney. Mr. Upper Torso.
I'm not a camel.
Okay, here we go. Courtney Shells, Mr. Upper Torso, and Kim R. You know, Mr. Upper Torso, that it is incredibly hard to say your name correctly, let alone sing it. There's the buffer sound again. Okay, hang on. I need like a list with all of them together. Mr. Upper Torso, happy birthday. Okay, okay, is it just these four? 1, 2, 3, 4. Is that all there is? Did I miss that? Okay, we have to sing happy birthday because court's going to start, which I need to get ready, which I don't even have ready yet. Hold tight. And I have a dilemma. Because my system that was set up to work is not working yet. And I need to record another court case that is in jury selection right now. And I have a court order that I'm allowed to record the court case, so I might need to hire one of you to record it for me. So if one of you out there has massive experience in recording, because I can't miss this, please reach out to me. Let me see if I can make a deal with you to work for me as a contractor briefly to record a court case through WebEx in the highest resolution possible. All right. That said, I'm panicked about that, honestly. I have no idea what I'm going to do. Let's see. Is there any other birthdays? Just say Mr. Upper, says Holly Mack. Mr. Upper. Okay, Mr. Upper it is. Even though we know it's Mrs., we're going to say Mr. Upper. Let's see. Timmer used the hood of the Dominator to view the eclipse, and when he zooms out, you can see the hail damage, and it's comical, says Jim Bob. That is awesome. Saw some amazing pictures of that all the way. That would be a subcontractor. Yes, subcontractor. Krista, that's correct. Now, let's see. KK, awesome. Casey Cat, welcome. Good to have you here. All right, we have to sing happy birthday for those that are new here. I think Courtney Shells, Mr. Upper, and Kim R are the only ones we're going to sing to. And if there's somebody else, I do apologize. Still got a little bit of a little scratch in the throat, but we're going to give it a try. Let's do a little warm up. La 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 la. Okay, we're good. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Courtney Shells, Mr. Upper, and Kim R. Happy birthday to you. All right, the four of you and many more. Actually, I think there are. Doda, we're going to include you in there as well. Anybody else that needs to be included on the list? Hopefully you have an absolutely fabulous birthday. I know there are a million places you could celebrate your birthday. Some of them give you free pancakes. We don't do that. We give out the internet. Or at least we try. Today I failed miserably at it. I don't know who it is. But anyway, congratulations on your birthday. Congratulations. We're glad we can celebrate with you. The privilege is ours. It really is. And I appreciate you guys being with us today. So have a fabulous birthday. Hope we can make it just a little bit better for you. And if I missed anyone, my heartfelt apologies about that. And I'll just include you on another days if that's on your unbirthday. All right. That being said, we have a camera from the courtroom, which is always good. Let's see. I think we're good there. Wallflower, member for 8 months. Thank you very much, Wallflower. We've got a huge crowd that's in yellow, which is just amazing. It's incredible. Happy birthday to all who are celebrating today, says Holly Mack. Yes, that is appropriate, and that's what I should be saying as well. Okay, I need... Let's see. Good morning, 80s Music Man. I see you here, slipping in the door as well. I'm going to turn down the music. This song goes forever. Who won the internet? This is a great question. Usually we give away the internet first thing, but it's... I forgot to tag whoever it was, and now it scrolled off the screen, and I can never go back there. So, Miss Lisa gifted 5 memberships this morning. Thank you very much. Those went to Mama Ames, Mary Viviano. Is that right? Yes, Ohio Lisa, Aaron Sweet, and Natalie O. It's wonderful. Thank you. How do you do your milestone chat? I think it's... I don't know. I don't know how to do a milestone chat, honestly. I can't remember. All right, let's turn that there. This here. We have... I think we got this right here. You know what I need? I need my objection counter. Hang on one second. All right, there was a buffer sound. Oh, here we go.
I just said doodah. We don't have a Doda bird. Don't worry.
That was super loud. I apologize for blowing out anyone's eardrums. We're going to turn that down just a tiny bit. Karen A. Scudder was first in chat. Karen, you've been outed. You've been your friends or acquaintances, former friends, as they might be now, have told on you. You being first in chat comes with a prize, penalty, or punishment, as it depends on how you view it. You own everything internet related. It's a gift from us to you to celebrate your momentous achievement. Congratulations for being first in chat. Just today, in addition to all your other duties, which you normally have to take care of, you also have to repair everything internet related worldwide. So just plan on that, and good luck. And if you could, in the process, fix my recording system, that would be great as well. So thank you, Karen. Congratulations and good luck. I'm looking for my plug for my objection counter. This judge is already back. Oh my goodness. Starting early. Ella Cole, thank you for your super chat. Let's see here. I just said, dude, we don't have a Doda bird. Don't worry. Okay.
Bring the jury.
Are we really at 946 objections? Can somebody tell me if this is right? Can somebody go back and watch where we were the end of last live stream?
Please tell my T80s Music Man is sorry.
Password PASSWRD123. Okay, now Judge is here. Here we go.
Happy Monday.
Happy Monday to you too, Judge. Thank you.
Is that correct?
Mary Murphy, thank you for the great comment.
Case number 2018 CA5321 Jack Kowalski, etc. et al. versus Johns Hopkins Hospital. Starting with the plaintiffs, let's take appearances, please.
Greg Anderson, Nick Whitney, and Samantha Lawrence on behalf of plaintiffs.
Good morning. Ethan Shapiro, Howard Hunter, Pack Rolls, joined by Dr. Beatrice Tappas-Sanchez for the defense.
Thank you very much. And what did you all wish to accomplish first?
We'd like to put the genie back in the bottle.
Exhibits. I think Nick's going to take the only one I have to start out, Judge, is 2528006, which is not on this
Mayla's mom, thank you
today, but has been the subject of prior attempts to get it into evidence. We pull it up for the court so he knows which one we're talking about. We call it the Ashley Judd photo. What's up?
So you said 2528, which
006.
So is this a reconsideration of something I've already denied?
Yes, sir. This is the best photograph we have of Beata Kowalski at the time that Beata's sister testified about her watching her father being taken away by the Polish version of the KGB.
I've made my ruling. Denied. Let's move on to the next thing.
Okay.
Who was laughing there? Who was laughing?
Your Honor, the court had several policies to review over the weekend.
Yes. Got them right here.
All right. Do you need me to discuss them again? Or?
Well, let me, because I know Ms. Crowell's was going to be looking at, or I'm assuming it was Ms. Crowell's, but perhaps Mr. Hunter, your team. So let's start with the meaty one, the determining legal guardianship for consent to medical care. Have you all had a chance to come to a position on this one?
Yes, sir. Obviously, it's one of our policies. Just as obviously, it's a large policy that encounters and covers a lot of different issues, most of which have nothing to do with this case. And so our objection would be relevance and lack of foundation of relevancy. Obviously, again, Your Honor has been letting these in if they're policies, but this is just 10 pages of policy that really doesn't have anything to do with the case, but for perhaps 1 or 2 paragraphs.
Well, are there paragraphs to which you agree, and then we can perhaps redact the balance?
There is a paragraph regarding number 2, court-ordered guidelines, DCF. That may be relevant to this. The remainder of it, we suggest the court is not.
So he's objecting on relevance?
So are you saying paragraph 2, sub A, little, I assume 2, or?
Basically 2, Judge.
Go to the next page, please, Dan.
Buttercup, thank you very much for the donation. Good morning, Rough. I'm spunky again. Rough. I got borrowed. Bite me's credit card. Glad you're feeling better, Buttercup. Formerly known as MD. Thanks for gifting a membership.
Your Honor, we agree that's the relevant paragraph. Paragraph 2, subsection little 2. We would ask that A2. Yeah, we would ask that on the first page, if you could go to that, Mr. Reyes, that we keep the top through Roman numeral 1 policy, just to give the jury the idea of what this is broadly, and we can redact Roman numeral 2 through the rest of that page, and then pick up again at number 2 on the second page.
Well, I think what you would have to do, I'm fine leaving in Roman numeral 1,
right,
and then where it says Roman number 2 procedures, leave that in. Redact starting with A through C, where it says D, leave D in that first sentence in, and then redact out starting with number 1, legal parent.
Sure.
Redact out the C on the top.
Yes.
Leave in 2A, and then number, is it Romanet 2? Is that how we call it? I don't know.
Yeah, I'll take that.
That's fine. Romanet, yeah. Wow.
And then everything else is redacted.
If we could go to the next page, Dan.
Just if you redact from,
go ahead, Dan.
If you just redact from the end of page 281, you've probably covered everything else. The following page has to do with court-appointed guardians, adoptions, and other custodial orders.
Is there any more? That was it. Okay. You can go back to the second page.
Okay. So that's the redaction. So as redacted, and we'll make it Exhibit 2277-280A and 281A. I I suspect what we also need to do is
Cynthia McKenzie, welcome to the gallery. Thank you so much.
all the way through 285, make it an A, and then redact it because it on the top where it says page 1 of 6. I don't want the jury to get confused.
Okay.
So
Redact
essentially, we're going to make this a 6-page document, all with A. So it'll be 280A through 285A, and most of it will be redacted, except for pieces of those 2 pages.
Terminator 61.
So can
thank
someone
you for
get a
gifted
printed
membership
copy
as well.
to the clerk at some point today?
We will.
Okay, so that takes us to the risk management policy. Is that the next one?
Yes, Your Honor.
Is that 2277 286?
289. I believe it's 289 to
Okay.
291.
And Mr. Hunter, is there any objection to the risk management policy 289 through 291 of
Basically,
Exhibit
Judge, just,
2277?
I'm sorry.
I was just trying to call out the numbers for our transcript. Oh, wait a second. I've got a Dr. Richards here.
Our first witness, Your Honor.
First witness.
Okay. Dr. Richards, this is Judge Carroll. I see that you're here. There's some items that we're going to address. Are you able to hear me right now?
I can hear you, Judge.
You're muted, sir. So I suspect since you're trying to talk, you are able to hear me.
How about now?
I can hear you. Yes, sir. I'm going to put you in the waiting room.
Thank you, Your Honor.
I know that you're.
I'm sorry.
I know that you're here. It's going to be a little bit after 9 o'clock when I call you back. Okay.
Would you rather I sign out and sign back in a little later?
You can stay on.
I'm in a hotel in Philadelphia. I was going to grab a cup of coffee before I started on the trial.
And Your Honor, not to interrupt, but there are some very significant issues we need to bring before the court on what we believe are a granted motion limited to exclude his testimony. So we will have to vet her before he testifies.
He's not testifying as the standard of care. That's the concern.
Okay. Well, Dr. Richards, if you want to sign off and go grab some coffee, that's fine. If I see you pop back in and then I put you into the waiting room, please understand that's just because we're not yet ready for you, okay?
Thank you, Your Honor.
So going back to the risk management policy 2277, pages 289 through 291, is there an objection, Mr. Hunter?
Just the relevance objection, Judge.
Okay. If the court's going to overrule the relevance, I will receive Exhibit 2277, pages 289 through 291. And then I think there was one more policy. Is that?
286, Your Honor.
That's the complaint policy, which is 2277-286 through 287. Any objection?
The same objection, Judge, in addition to which there's just been no foundation laid that there was a grievance here. So that's the objection.
Okay, the court will overrule.
Objection to relevance. Can I just ask what is relevant to what count?
It's relevant to the defense's argument that the Kowalskis failed to complain. They failed to raise an issue with the care that was being offered. So the onus isn't on them completely. What? And this policy sets that out.
And it goes to our negligent training count.
And that's where I want to get to. We've never really ever resolved what their negligent training count is. And I filed
there might be a
motions
directed
for
verdict.
a special instruction resolution of this, and they still have this winding theory of negligent training that I don't know what the law is on this. So it's hard for me to tell them what to do on relevance because
you need to
it's
study
a
the
common law claim trying to allege negligence for supervising people who have a medical standard of care. And so all of this stuff has been coming in under theories that I really don't think are proper legal theories.
Yeah. I think this is relevant in addition to what Mr. Whitney said. I mean, we've already seen there is knowledge on the part of risk management that Maya Kowalski feels like the hospital is lying and patients are lying to her, and there doesn't seem to have been any sort of effort on the part of the hospital to address that issue, whether that
Did that cause a personal injury? What did that cause? I mean, does this go to the intentional infliction on my end?
It can.
I mean, if it goes to that, I understand it. But if it goes to some of these other counts, I don't understand.
I mean, when I saw this on Friday, the very first thing that popped into my mind is it goes to the intentional infliction of emotional distress count. Now, can it also go to other counts? Sure. But when we just talk about relevance, I feel this is relevant, and I am going to admit Exhibit 2277-286 and 287.
Okay.
I think it goes to 288 if I'm not, am I wrong about that? It
does go to 288, Your Honor.
Okay, and 288, I apologize. So 286, 287, and 288. Okay, what's next?
Next, Your Honor, is another risk management note, 2277-453.
2277-453.
I haven't looked at it, Judge. We just got told that. I'm not complaining. I'm just saying I didn't have a chance to look at it. They told us this morning.
Yeah, you're complaining. They told us this morning.
Yes, Judge. This has already been ruled out.
There was a withdrawal ahead of the witness testimony. We were crunched for time, but we'd like to readdress. And there was no ruling. It was our withdrawal. Now, recognizing that we see David Silverstein, the DCF attorney, and the name of Ms. Salisbury, and there may need to be some redactions. This is another note talking about the hospital's theory that these were the lesions were self-inflicted wounds, and you see the names of Dr. Elliott in anesthesiology. Then you see down below, nursing notes, pull out first note now. Social worker supervision pictures. Ooh. There's also, I see now.
Well, time out. Is there any evidence that a note in the medical chart has been removed? Is there any evidence to that?
This is the evidence. How would we have evidence of a note that they pulled out and destroyed other than this note?
Judge, that is such a huge leap. Plus, they want to redact contextual clues like David Silverstein, an attorney, Salisbury is an attorney. This gives the jury no information and just gives them a leeway to make speculative arguments in front of this jury with no evidence to back it up. It's an interpretation.
This is evidence, though.
Required that nobody is testifying about.
What's the top right? What does it say?
When a peer document why talking to the picture?
Dr. Elliott again.
I'm assuming at the hearing, maybe? I don't know, Judge. That's the problem with this note.
When a peer.
Reasonable inferences are left to the jury.
No, it's not a reasonable inference, Judge.
Nursing notes pull out now. What's the reasonable inference?
Well, you don't know if that now goes to nursing notes pull out. There's circles, there's notes written all over the document. There's no connection to now. Maybe that meant let's have a meeting now. Well, there's no way to interpret that.
That's for the jury. All right.
No. Even though this is in the risk management file, there's not enough in this note, and there's too much dependency matters to be able to appropriately.
Did they shred a note?
Redact it without changing the likely context. So I'm going to not allow 2277-453. What's next?
And Your Honor, if this does come, if there is testimony surfaces or an issue regarding this, then we could still use it for impeachment and cross-examination, can we not?
Well, all I'm ruling is right this second is not coming into evidence.
It's not going to make any future rulings.
What's next?
Your Honor, 2221 we do not need to address because we admitted the risk management file below. And then 2246 would be the next.
Did Mr. Whitley get a little sun over the weekend? Or is it just the
court policy?
The picture
previously admitted what is an attachment to this policy. This is the matrix. The attachment would be the matrix that set out that there needed to be a psychosocial assessment. So in the interest of completeness, we'd like to admit the policy itself.
How many pages is this?
15.
7 pages, John.
That's a good guess.
Judge, I'm not sure how this is relevant to the issues in front of this jury. And I think it's just going to confuse them.
I've already ruled that the Johns Hopkins Children's Hospital made the report to the hotline in good faith, and there's immunity that attaches because of that report. I don't see why we need to put in the policy about making the report, because the actual issue of whether to make the report or not is not an issue for this jury. So the court will exclude 2246.
Judge, we're fine with redacting that. We're more interested in the procedures leading up to that without any mention of calls. We simply want the jury to know what the procedures are in evaluating these and diagnosing these before and it doesn't have anything to do with actually making a call, but in any circumstance, whether they make a call or not, there are certain procedures that they have to follow.
2246 is out. What's next?
I think that's it, Your Honor. We had this letter from Deborah Salisbury, but I do believe the court's previously ruled on her written communications to the hospital.
Let me just, because you're going to be resting this morning, right?
We are, Your Honor.
Okay. So I need you to make sure if there's any exhibit that you're going to need in your case in chief that is not yet in.
Now's the time.
Now's the time.
Understood. Do you have anything else for Dr. Richards or Dr. Corcoran?
Judge, they're also calling more witnesses than they had indicated on Friday.
We've got more than Dr. Lawrence. Sorry, Miss Lawrence.
That's okay.
I just scanned the room and saw you. Dr. Richards.
Dr. Richards, and then we have a few questions for Dr. Corcoran, and that's it.
You're not calling Deborah Salisbury?
No.
Oh, okay.
No time.
Okay.
You don't have time to call one of the witnesses.
That's in.
These are in. These two. 5. And
should all be in.
all right. So this is all in. Okay.
Judge, if the court please, we have issues with respect to both Dr. Corcoran and Dr. Richards.
More objections.
Do I have a written motion on this?
In terms of Dr. Richards, the court's already ruled his testimony is motion and limited out, and I would direct your attention to the court's order on defendant's motion limited DIN 3410.
Ooh, the witness is
What's
limited
the
out.
DIN number?
3410.
3410. Enter.
Okay, so if I've already limited his testimony, what are we? Is this a reconsideration, or I mean?
They have not moved for reconsideration. We moved to exclude his testimony. The court granted it, and specifically, the court found that he could not offer standard of care opinions of equal importance on causation. The court wrote on page 4 of its order, plaintiff's argument that Dr. Richards' testimony is relevant to the claims of intentional infliction of emotional distress are unavailing. This exact issue came up. I have the hearing transcript if Your Honor wants to hear it. We argued that Dr. Richards should not be allowed to speculate to this jury as to what the out-of state of mind was, what happened at the hospital may or may not have contributed to her state of mind and the intentional infliction of emotional distress. The court granted our motion on both standard of care and causation. I have no idea what's left. I don't know what he could possibly testify to. And they've never moved for reconsideration of this.
What do you need? Well, I don't see who's putting it up?
Dan is putting it up on the monitor.
Please. What are you looking for? I'm looking for the specific language. My understanding, Your Honor, is
Dr. Richards is listening in to this.
No, he just came in, and as you were saying.
I understand.
No, I just want to make sure the transcript's clear. The comment implied he was already here. He was coming in. So, Dr. Richards, I'm going to go ahead and place you into the waiting room.
Wow.
Okay.
It's a fun morning.
I've got my order up.
Move to reconsider.
So, what is this witness going to be used for, Mr. Anderson?
he is testifying, as we've stated in the notice and in his deposition, in his report as to whether Beata Kowalski acted on an irresistible impulse in her suicide. And there's the court's order and their argument, and I've seen the transcripts as well, was based on the determination that Dr. Richards is not qualified under 766.102A as to standard of care opinions. He is not testifying in any way, shape, or form about the standard of care of any physician here. He is a causation expert as to the suicide. And I did not read this order as excluding him from testifying within the disclosed area. And if the defense wanted to exclude him as to the suicide itself, then that should have been part of their motion. And we do not read the court's order. We read the court's order as directed towards Dr. Richards saying anything having to do with Dr. Cabot or Dr. Katzenstein may not be allowed, and any other physicians. And so what was not addressed, and so we did not ask for rehearing because the court didn't order that he couldn't.
Well, let me ask this. Was the original underlying motion directed to the irresistible impulse under a intentional infliction theory?
Yes, Your Honor, and that was specifically argued at the hearing transcript.
Do you have that transcript for me, please?
Yes, Your Honor, if I may approach.
Sure. And this is the hearing transcript from September 11th, 2023.
Yes, Your Honor.
And Dr. Richards is a psychiatrist.
Yes, sir. Yes,
He's a
sir.
board-certified psychiatrist licensed in Florida.
Correct. I'm going to get into that too.
35 years of experience.
If they rule this one out, they might call Dr. Salisbury. Let's see what happens.
Okay, anything further?
Yes, Your Honor. This was an order in limine, which the court may readdress at any time. We did not read this order as excluding him from testifying about the circumstances of suicide, why people commit suicide, the circumstances leading up to it. And at the time of this, both this order and at the time of his deposition, the court there had yet to be any discussion of exactly what was going to be in the jury instruction. So it was hard to ask specific questions at those points. Now, Dr. Richards has evaluated 10,000 potential and suicide victims and unsuccessful suicide victims in 4 different distinct categories. And it would benefit the jury to understand more about the irresistible impulse term, because it is a term of art there. And so, again, I do not see if, as long as we stay away from any standard of care, I don't see where his testimony is excluded. I grant you that there's language about intentional infliction, but there is more to that than simply the suicide. So,
and I'd like to point out also, Your Honor, at DIN 2528, the court denied the defendant's motion in limine to exclude testimony pertaining to causation of Beata Kowalski's suicide. That's an order in the lead up to the last attempt at trial on March 28, 2022.
Mr. Whitney pulls out the trump card. Let's see which one.
Mr. Shapiro, are you arguing this one?
Just two issues. One, obviously, this is the order that's controlling in advance of trial. I don't think Your Honor could have been any more clear in your order on the motion in limine that, quote, plaintiff's argument that Dr. Richards' testimony is relevant to the claims of intentional infliction of emotional distress are unavailing. As you've seen from the hearing transcript, this was exactly what was argued by my colleague, Mr. Hunter, that not only are they trying for standard of care, but they want to bring Dr. Richards in to talk about the state of mind of Beata. This was motion eliminated out. I would just add, if Your Honor is inclined to abide by the previous ruling, I can stop, but this is going to open the door tremendously. If he's going to talk about substantial factors of Beata, then the only way we can cross-examine this is to talk about the substantial factors, including her fainting at the first dependency hearing, the fact that there was other final adjudications coming up on February 21st that could have been a substantial factor. But again, I don't know that we need to get into this because it looks like the court's already dispositively ruled on Dr. Richards. And as I know, this court's frustrated by our attempts to try to move to exclude experts on the morning of their appearance. This is an attempt by the plaintiff's counsel to seek relief from a very clear order from this court on the morning before Dr. Richards is about to testify. I don't know that Your Honor could have been any clearer on this exclusion.
Well, let me give you my thoughts right this second. Certainly, it's clear that he can't talk about the standard of care, especially with those other doctors. And to me, that was the thrust of the motion. Now, it is clear that there was discussion about what Mr. Anderson is now identifying as the irresistible impulse. I feel that I might have made a mistake on putting in that sentence, because the issue of irresistible impulse is an issue in this case, and I don't see how this doctor wouldn't be allowed to testify. Now, if I'm going to be changing my ruling on this issue, obviously it impacts the defense. So I don't know if he would need additional time to prepare a cross-examination for this witness, since I think I am going to reverse myself on this issue.
Judge reverses himself. Only on the rare position.
Irresistible impulse, not on the inability to talk about the standard of care as to the other doctors. I think that's going to be
further argument from the defense here.
Yeah, that was under our understanding, Judge.
So, but since I think I'm going to be changing my mind on this, I'm asking if the defense needs more time to prepare.
Well, I think what we would need is a proffer as to exactly what he's going to say outside the presence of the jury, so we can decide what the cross-examination would be. Because again, my concern, Your Honor, is if he's going to come in, and I mean this respectfully, and speculate onto Beata's state of mind as to what she was thinking at a given point in time, and that the fact that on this particular day, based on what Judge Hayworth said to her at the hearing, is
that's not part of his opinion.
You see, it's hard for us to prepare a cross because I don't know exactly what he's going to say, but my concern is if they're going to say that something happened that made it a substantial factor or suicide, the cross-examination of them has to include, and I think the door's already been opened perhaps by Mr. Kowalski's testimony that Beata killed herself to free her daughter, when we know that there was a final hearing on this on February 21st, but we cannot defend against a substantial factor, whatever the test is going to be on intentional infliction, especially through expert testimony, if we can't bring in all the other substantial factors that we believe were actually causative. So maybe
the irresistible impulse is supposed to be part of this foreseeability for this whole tort as compared to an expert opinion as to the different factors that make people this way. But it's because the intentional infliction has to be what we had been proposing early on was a substantial factor to the extent that it's an irresistible impulse. But if he's going to put on someone who never saw her ever in his entire life or her entire life to opine on she had an irresistible impulse at the time she committed suicide, we're going to need to go through whether or not the separation by the court for 100 days, whether or not the supervision orders from the court are a factor in this, and especially whether or not the things that immediately precede the suicide that occurred inside that courtroom are a substantial factor in why she decided to commit suicide the next day. And I mean,
I feel like I got this call wrong. As it relates to the irresistible impulse issue. I'm sorry, I feel like I got that one wrong. And so I'm allowing or inquiring, because I'm assuming you took his deposition ahead of time. So it's not like you didn't have an opportunity to talk to him. It's just preparing for his testimony today based on the court's prior ruling. I can see that was impacted you, and I would fully recognize that. So that's why I was asking those questions.
I think the best way to handle this procedurally, noting our objection for the record, is to hear a proffer from him on what he would testify, and then allow us a little bit of time before we inquire and bring him back in front of the jury.
Well,
like a break.
He's here now, so what I would suggest, Your Honor, I would point out that the defense
Start the day with a
spent
proffer.
at least 6 pages in the deposition going through the suicide and going through the culminating events and going through diagnoses and going through, in fact, he gave the authorities that he was relying on, not that he can testify to them here. The point being, if we can call him, I have no problem with making arrangements to bring him back later if the defense would like to cross him after however much time.
I am going to go with the defense idea of doing a proffer.
Sure.
Let's tell the jury it's going to be a little bit of time before we call them in and just get them to be comfortable. We'll talk to them now. And
somebody ordered donuts for the jury.
Where it gets us.
Or bagels, I guess. It's still early in the morning for sugar, but...
To further gum up the works, Judge, we were told yesterday midday that Dr. Corcoran would be coming back. We've not been told why. We haven't been told what the scope of his prospective testimony is, and we'd like to get some idea of what that is before we get bushwhacked on that.
Can you tell us why Dr. Corcoran's coming back and what it's going to be for?
Yes, Your Honor, I could have sworn I sent a text over to counsel that explained this, but he is testifying on direct. The court may recall that he testified to his concerns over the setup of information flow in the management, and he covered in there the negligent training, the improper and lack of training to the nurses and staff baiting on this. I am bringing him back to testify as to the negligent training of the doctors, which I neglected to ask him about during the course of his testimony. Now, we spoke about this topic, but we did not get into the doctor. For some reason, I didn't include the doctors looking back on it. And I am fairly confident I sent a text over to both counsel in the morning, yesterday morning, and let them know what he was talking about and what he was going to do. If the court will give me a moment, I'll try to find it here.
It's not okay.
Mr. Hunter's like,
you have an idea now as to why. So can we just start with the proffer of Dr. Richards?
Yeah. But on that, where he's going is he wants to have an ordinary, reasonable, negligent standard of care for hospitals to train doctors. And that's just not the law. It's not in 766. It's no place.
Okay. Can we deal with that issue after we deal with Dr. Richards?
Yep.
Sure.
Okay.
Just one issue.
Dr. Richards. Where
is he issue at a time.
From?
Dr. Richards is on
he lives in Port St. Lucie, but he is actually had a death in the family, and he is in Philadelphia. So that wasn't enough for all the other stuff that happened. He had a death in the family, and he was up there for a funeral. So he is at a Marriott in Philadelphia.
Too bad it wasn't a Holiday Inn Express.
Can you put it on the screen so that everyone can see?
Just a moment, Your Honor. Do you require me to go through background training experience?
Not really.
Okay, Dr. Richards, this is Judge Carroll. I understand you are out of the state of Florida currently. Is that correct?
Yes, sir. I'm at the Philadelphia Marriott in the airport. I arrived last evening. I was at a very significant family event this weekend.
I'm sorry to hear that. Now, let me go over a couple things. First, the jury is not in our presence right now. What we're going to do is a proffer. We might have to do this twice, once now and then perhaps in front of the jury. Okay, so just to let you know that there is no jury right now, and I'll tell you if the jury is back so you understand that we might be asking the same questions again.
Thank you, Your Honor.
The next issue is my powers go to the state line. For me to administer the oath to you, I need you to consent to me to do that. What that means is, even though you are in Philadelphia right now, you're actually testifying in Sarasota County, Florida. And if there was ever any type of enforcement action or perjury action against you, you consent to jurisdiction in Sarasota County, Florida, because that's actually where you are making your testimony. Do you understand that?
He looks really
Yes, sir.
And with that understanding, may I go ahead and swear you in?
Yes, sir.
Please raise your right hand. Do you solemnly swear or affirm the testimony you give is the truth?
So help me God, yes.
Thank you.
Dr. Richards, this is a proffer, so we can forego your background training and experience other than for me to ask you, are you a physician licensed to practice medicine in the state of Florida in the area of psychiatry?
Yes, sir.
And were you tasked in this case to evaluate the information regarding Beata Kowalski and her suicide towards a determination of whether or not Beata Kowalski acted on an irresistible impulse?
Yes, I was.
And briefly, since this is a proffer, can you give the court some idea of what you went over towards offering those opinions?
I received in May of 2018 copious amounts of medical records, which Mr. Anderson's office had asked me to review without any information, just asked me to see if there was any significant medical issues. And that was the first incidence I had to review the evidence and the events in this case. I subsequently have reviewed a vast majority of depositions. I've reviewed Beata medical records. I've reviewed Maya's medical records. I'm not sure I could list all the medical records in the time we have today that I've reviewed in the last 5.5 years.
All right.
Dr. Richards, is there any way that you can go close the blinds?
Yes, sir, I can.
Thank you.
Dr. Richards is closing the blinds in the Marriott. Nice. Now we have the mood lighting.
Is that better, Your Honor?
No,
or should I turn the light off?
It's better in the sense that I can actually see a little bit better now. So
turn the light off. Turn the light off.
I know the glare sometimes. My apologies for this, Your Honor. I had planned to be here last week, and
I understand the circumstances. You don't need to apologize. That's better than we were at. So thank you very much for doing that, Mr. Anderson. You may continue.
So, Dr. Richards, then, can you give the court the benefit of the methodology of your analysis towards determining what drove Beata Kowalski to the suicide and the basis therefore? So right now we need to talk about methodology.
Well, in terms of reviewing the case, I tried to review Beata's personal history, her past history, her familial history, her family's history of any issues that went forward, events she may have gone through in her life prior to coming to America, her time in Chicago, leading up to the time of her daughter's diagnosis, and subsequently to the time of her death. This included reviewing her family history, as I mentioned, in Poland, her Catholicism history, her basic personality in terms of phone calls that I did review and letters that she wrote. I think that's pretty much most of what I covered. I'm not sure if there's anything else I could add.
And as a retained expert in this case, did I provide you information concerning the testimony of Beata's sister in this case to the effect that she had witnessed her father, apparently a dissident in Poland, being taken away by the state?
Yes, you have.
All right. And so now, again, this is briefly now. Can you describe to the court then your analysis leading you to your ultimate opinion as to how or what caused Beata Kowalski's suicide?
I can. I want to apologize. My records are in Florida, but I have been in this case for a long time, so I'm going to do most of this out of memory. In my opinion, this case centers around the fact that Beata Kowalski was placed in a situation where she had all of her personal and psychological defense mechanisms overwhelmed by the system of Johns Hopkins in their behavior towards her. In this, she lost her own personal identity. She lost her professional identity. She lost control over all areas of her life. And we know in psychiatry that conflicts of loss and control lead to emotional instability. And as she lost more and more of her control over life and had all of her defense mechanisms overwhelmed, it is my opinion that the last defense mechanism that she had left was some altruistic surrender, where she, in a sense, was able to put herself in a bullet in the path of her daughter. An altruistic surrender is basically giving up of yourself for the health of another.
What, if any, effect were the parental instincts and survival instincts in conflict?
That's a great question. People have talked about maternal instinct, and during this case, I reviewed some of the biological literature, the human literature, and it's unequivocal that the maternal instinct is a biological and sociological phenomenon that is there even prior to birth. We find changes in hormones, we find changes in the brain activity and the MRI. There have been instances where women and animals have shown anger and erratic behavior in an attempt to protect their offspring. And to me, in this case, I felt this was a very strong indicator of Beata Kowalski's state of mind, although we aren't able to speak with her directly. Based on reviewing of her writings, on her telephone calls, her education, I feel this is an intelligent woman who basically overwhelmed the defense mechanisms, and the only action left was altruistic impulse.
And so can you then describe for the court, in your view, based upon your review of the records and the facts leading up that evening of Saturday, January 7th, to her suicide, how you believe this was, as you said, an irresistible impulse?
In my opinion, the events that had led up to this, and specifically the multiple court cases, the hospital refusing any contact with her daughter, I believe her final overwhelming event was being told she was going to continue in this for an extended period of time. And human beings, every one of us has a tipping point of stress to which we cannot tolerate anymore. We literally learn helplessness, and we just let the process take. There's a specific study where mice are put in and shocked, and after a while they stop trying to get out of the cage, and they just allow themselves to be shocked and they die. And in a sense, to me, this is the human portrayal of that animal experiment. This woman had done everything she could to prevent harm to her daughter, to protect her daughter, and the only aspect she had left was the altruistic surrender of her life.
And so what role did Beata's knowledge, as you've been able to discern from the record, as to the way that her daughter was being treated, as communicated to her by numerous sources, in particular the actions of Ms. Beatty and others at the hospital,
the court's pushing this into us
she received during the course of Maya's stay at Johns Hopkins?
I think there's a variety of things that went on. Specifically, though, that once it struck out to me during this case is the concerns of Maya, the mother and the father, of retaliation upon them. And that fear of retaliation specifically to Maya, which I did see earlier in the case, that Maya herself, which I had not had the opportunity to know, Maya herself said that she felt a fear of retaliation. In this aspect, I have a sense that as an adult psychiatrist, human beings who are parents, when they fear their children will be in trouble because of their actions, are fearful now of retaliation to their children. And based on the events of the 80-plus days in the hospital, to me, it's very apparent as a psychiatrist that there was a significant fear of retaliation to her daughter based on her behavior. And I feel strongly in my professional opinion as a board-certified psychiatrist that that was a major factor in her impulsive suicide.
Do you have an opinion based upon your background, training, experience to a reasonable medical probability as to whether the tipping point, so to speak, to Beata's suicide was learning that Kathy Beatty was abusing her daughter?
That, to me, is a massive piece of information. Any parent that would find out that their child as being psychologically, physically, emotionally, or any of the above would have an absolute enragement and would cause impulsive, distorted thinking.
So on this evening of January 7th, 2017, do you have an opinion based upon your background, training, and experience into a reasonable medical probability as to whether Beata Kowalski acted on an irresistible impulse to take her own life?
Can you repeat the question again, sir?
Sure. Do you have an opinion based upon your background, training, and experience into a reasonable medical probability whether on that evening of January 7th, 2017, Beata Kowalski took her life based on an irresistible impulse to do so?
Yes, sir, I do have an opinion.
And what is that opinion?
It is my professional opinion that Beata Kowalski's suicide was an impulsive act based on her cry to get her daughter home, and it was her final option. And in my opinion, based on her life history and her religious aspect, I feel that she, in a sense, made a deal with God of take me instead of my daughter. In a sense, it became similar to a Sophie's choice that we now know about, an impossible decision where there was no right answer. And that's why I differentiate this from altruism to altruistic surrender. In altruism, you do something nice for someone else, knowing that you'll be nice about it. Surrender is you don't care what happens to yourself, and you do what's right for the other person despite what happens to yourself.
Do you have an opinion based upon your background, training, and experience to a reasonable medical probability as to whether Johns Hopkins' actions in continuing to allow the interaction between Kathy Beatty and others with her daughter and Beata's knowledge of that was a substantial factor in her suicide?
Yes, I do, and I feel it was a strong and significant substantial factor in the events that led to her eventual demise.
Your witness.
This testimony is critical in linking.
Based on this testimony, I'd like Dr. Richards excluded.
Okay, Dr. Richards, I'm going to put you back into the waiting room. I suspect it's going to be a few minutes, okay?
Thank you, Your Honor.
This witness is crucial for linking the hospital in liability to Beata's death.
Dr. Richards is out of our presence at this time.
They're going to talk this over a little bit, but basically this puts the responsibility in the hospital.
We again renew our motion to exclude on several bases, but most importantly, Dr. Richards' testimony was unequivocal that the suicide was to get, and I quoted it was a cry to get her daughter home. All Children's Hospital is not responsible for the separation of Maya from her family, period, point blank. And that is the reason for the suicide. For this witness to come up and take the stand and tell the jury that this was some Sophie's choice, that the only way to get Maya home was an act of suicide, is going to violate this court's order. Respectfully, we're going to be moving for a mistrial if he says this on the stand, because again, this is the 5th, 6th, 7th time in the case that the plaintiff wants to proffer testimony in front of this jury that All Children's is responsible for the separation, and the only way Maya could come home is because of the separation. Going further, the testimony of him in terms of what he saw as inflictions were, according to Maya, that does not go to the question of intentional infliction of emotional distress on Beata. So for multiple, and then the third problem with the testimony, even if this court were to try to walk the line, and I understand Your Honor's doing, this court's doing the best they can, the only way for me to cross-examine this witness on this concept, the overall concept of the only way to get Maya home was to sacrifice herself, I have to be able to talk about things like, well, there was an opportunity to sign a safety plan earlier on in the case. Was there not, doctor? Where they could have gotten Maya home. There were chances to transfer that they refused. There were delays in court hearings that could have expedited this, but the family chose Dr. Chopra out of state to go and have the evaluation. The family chose Dr. Duncan to do multiple evaluations. The family chose to have Dr. Hanna come to All Children's Hospital to do an evaluation, but unfortunately he didn't apply for privileges. So that process got delayed, and are you aware there was also a final hearing determination on February 21st where Beata could have gotten her daughter back and proved her, innocence or whatever the term is. And so this witness, A, is not qualified to speculate on someone's state of mind. We would ask the court to respect the order. Number two, his testimony is all about the separation. And I think Your Honor heard the only way to get her home was because of the separation. And through the cross-examination, I just don't know how to cross-examine him without blowing the door open on dependency, which none of us want to do. So we're in a huge pickle on this, Your Honor.
What about the testimony he said that a large part of his evaluation and his opinion was based on the Kathy Beatty abuse?
The unequivocal testimony in this case is Beata Kowalski was not aware of that or the photographs. Mr. Kowalski unequivocally testified on the stand that he was not aware of the photographs, and neither was she. So that can't be a basis, as a legal basis, for her to have committed suicide.
There was other abuse other than those photographs.
Well, I know the testimony was that she hadn't seen the photos. I thought the testimony was she understood what happened, because it was the brother of Jack Kowalski who took Maya to the courtroom that day, of which Beata was there.
Judge, but there's no testimony, in fact.
And Maya told
No, there's no testimony. No. In fact, I believe in his deposition, he didn't know about him. He never mentioned it to him. Never mentioned it to him. But further, Judge, the only connection, the only claim alive in this court connecting anything to the suicide, they have to prove intentional infliction of emotional distress on Beata, not on Maya. That's the connection. If they don't have evidence of intentional infliction on Beata, then there's no basis to connect this case to the suicide. That's their claim. They have to prove intentional infliction on Beata. I don't think you can prove that by showing we did something bad to her daughter. That is not intentional infliction on Beata. That's intentional infliction on Maya, which still is an existing claim. So how is that connected to the suicide? Because the only framework for the suicide is they have to show intentional infliction on Beata.
Let me hear from the plaintiffs.
Beyond the January 6th incident, Your Honor, Mr. Kowalski testified that with the child abuse hearsay, the December 2nd notes, that he relayed those to Beata Kowalski. So she was acutely aware of the mistreatment of of Maya at the hands of Johns Hopkins Hospital.
Plus the phone calls.
And the outrageousness of that conduct to any mother-daughter is apparent. It's common sense that if you inflict that kind of abuse on a child patient, you fail to address the fact that she's being lied to. You continue to allow this social worker, even once you have notice from the family, and there are several letters from Ms. Salisbury that are not in evidence yet, but go to notice to the hospital that Ms. Beatty was abusing her in this manner, and the family was aware of it, and they were asking for the hospital to address it.
That was a threat.
So Beata was acutely aware by the testimony here by December 2nd, or shortly thereafter, of the maltreatment by Beatty, and the infliction of emotional distress on Beata is what this doctor is testifying to.
Not only that, Maya testified to her ability to tell from the inflections in her mother's voice, the way her mother's approach to calling her, talking to her, the way that Beata seemed as time goes on to run out of things and become more hopeless, that Maya knew and could tell that the effects on her were having a tremendous effect on her mother. So on intentional infliction of emotional distress, it does not matter. Causation is for the jury. And so it's rather obvious, considering the testimony, that this was directed to Beata because Kathy Beatty has testified, well, it is testified to by Maya that Kathy Beatty was telling her that I'll be your mother, I will become your mother. There was intent there to separate out Maya from her mother. And Beata knew this, and Jack Kowalski testified to this. So given all reasonable inferences and the fact that we have two ways, the substantial factor and the irresistible impulse, so long as there is a causal connection found by the jury, then we succeed on this. And so, go ahead.
Yeah, and he reminded me of one thing, which is that Ms. Beatty's comments were directed at Beata regarding her being in a mental institution. So those are comments directed at the mother. They're outrageous. When she learns of these have the intended effect of causing her immense distress.
And Dr. Elliott said the same thing.
Judge, the comments, alleged comments by Ms. Beatty to Maya is not, that's why that count's still in, or was in, until they dismissed Beatty. The court dismissed and gave summary judgment with respect to intentional infliction on Beata for Beatty's actions because Ms. Beatty had no communication with Beata other than on a couple of calls redirecting her for not talking about things. There's no evidence that there were any comments or outrageous behavior by Ms. Beatty to Beata. And how the court could create some sort of intentional infliction on Beata because of some comments made to a daughter, it would be forging completely new path in the concept of intentional infliction. So they want to say, we caused a suicide, but the only vehicle, the only legal vehicle in front of this jury to connect us to her suicide is if their court finds, or the jury finds, that we did intentional infliction of emotional stress on Beata, not on her daughter. And there is no evidence of that. And this expert's testimony said nothing to that. It was all about getting her daughter home, and she was aware that she believes her daughter was being mistreated. That's it. It's the court hearing and what's being done to her daughter. That's not sufficient, and this testimony should not be allowed to further confuse the jury.
In Your Honor, Ms. Crawls brings up a good point, which is the direct interaction between Ms. Beatty and Beata.
Yes.
Including what Dr. Richards touched on here, which is the importance of her Catholic faith and the evidence in the record that Ms. Beatty felt compelled to interrupt prayers. We have the guardian ad litem testifying that she felt it improper, that Beatty's expressed to her directly that she felt it was inappropriate that Beata would attempt to pray with her daughter, contrary to the patient's Bill of Rights at the hospital. So that is direct interaction between Beatty and Beata to provide the immense emotional stress.
First of all, that testimony was...
Mention all of those, redirect.
First of all, that testimony was that Beata had hung up and the comment was made just to the guardian ad litem supervisor. So, again, there has to be intentional infliction, outrageous behavior to Beata. There's no testimony. And his testimony, the expert's testimony, doesn't even say that's true. He's talking about what was done to the daughter and the mother's desire to bring her home.
All right. Now it's about all eyes on the judge as he weighs this option, sees what he wants to do. I think defense has a pretty strong argument here.
What is the act against Beata Kowalski?
There has to be an act.
Because I'm hearing what Ms. Croyles is saying, and it's got to be an act against Beata, not Maya.
The act against Beata Kowalski is Ms. Beatty's fabrications that Beata was an unfit mother. She was in a mental institution. Ms. Beatty suggesting that she would take the place of Beata. Although in that call, the conversation where Jessica Blackrick informed Ms. Beatty that the family had a right to pray, before that, Ms. Beatty interrupted the prayer, and Beata asked her, what's going on here? Why can I not pray? I'm trying to pray with my daughter. So although the comment about having a right to pray was made outside the presence of Beata, the interference with her right to pray was directly upon Beata.
Well, and right now in my mind, I'm probably conflating an issue of law for me, which is, are those acts sufficient for intentional infliction? And if we're just talking about interfering with the right to pray, it's a different issue as to whether that would ultimately rise to save the count.
Isn't the test? And I'm sorry, Your Honor, I didn't mean to interrupt.
Well, like I said, in my mind, I'm conflating two issues right now. We're talking about Dr. Richards' proposed testimony, and I'm trying to square in my mind the acts towards Beata Kowalski as I'm examining this count on the wrongful death component of intentional infliction of emotional distress. So,
well, to me, Judge, it comes down to the intent of Beatty and others in the hospital to harm Beata. There is no question that the actions of Beatty were outrageous and intended to harm Beata Kowalski. Maya Kowalski testified to that. The next question is then, were those then communicated to Beata Kowalski such that she knew what was going on to her daughter and that it was directed specifically against her? They were trying to harm Beata. And so it's not simply the actions against Maya, it is the fact, and really this all comes down to the jury's view of the knowledge that Beata had of the situation that her daughter was in. And by any stretch of the imagination, the situation her daughter was in was dire. Beata knew this. Beata was kept up to date by Jack Kowalski on all of these things. Beata herself was dealing with Kathy Beatty over the phone. Beata Kowalski understood the intent here was to take her daughter away. And that is the outrageousness of the act that gets us through on this count. And we have been arguing this now for 5 years, off and on, in the pleadings and so forth. And we have alleged and we have proven, I believe, everything that was in that cause of action in the complaint. And so what it comes down to here is the jury's determination of, is it enough? Is it, in our view, it is overwhelmingly true and overwhelming evidence that this was not just simply at Maya. That wasn't, they may have had some intent as to Maya because they felt she was lying. But the intent of all of these actions was to separate her from her child. They wanted this acting out. They wanted to provoke. And in fact, they did provoke, and they got the result that they wanted, which is either, let's just say, Beata out of the picture one way or the other. So to me, the issue of fact here is whether the degree of communication of what their intent clearly was from their actions to Beata, and whether those are sufficient under the court's instruction and the instructions that will arrive at on this. And in this circumstance, if there had been no contact between Beatty at all, I think there still would be enough so long as Beata clearly understood that the idea here was to take her little girl from her. That is outrageous.
Remind me, was there testimony that Beata understood that Kathy Beatty from the hospital implied or proposed to Jack Kowalski a divorce? Do we have evidence that Beata knew that?
No.
I thought so.
Yeah.
No, Judge, but again,
if there's any problem with that, I'll put it back on. I'm certain that it's true that he communicated to her about that. And remember, Judge, this was not exactly an isolated thought here, because the Kowalskis later on themselves had it suggested to them about it. So Beata was clearly aware of the, I don't know if you call it danger or what, but Beata knew that Beatty was trying to separate her, and I believe the testimony will be from Jack Kowalski, that she knew, Beata knew that Beatty had suggested to Jack, have you ever thought of getting a divorce, or words to that effect, we should get a divorce. Some words that indicated the important thing to me anyway here is whether Beata understood that the mission, the purpose here was to take her little girl away from her. That's the outrageousness of the act. I mean, the outrageous stuff, the battery and everything against Maya is of course incredibly outrageous. But in this circumstance, the important point is it was part of a plan, and that plan was to separate Beata from her daughter and create an atmosphere where Beata would go nuts, essentially. That she knew her little girl was getting abused. She knew there was a woman in there that she could not get to, so to speak, or could not defend her daughter from. And that's what drove her into the suicide. It wasn't... that's the best way I can put it. I cannot imagine anything more outrageous than planning and intentionally trying to communicate over to Beata in every way that Beatty and the others had, that we're going to take your little girl away from you. And we're not going to do it legally. We're going to make sure we're going to use this system and everything we can do here, including hurting your little girl, to drive you to the point where you either act out in court, and so the judge does it, or you commit a crime and the criminal justice system does it, or you take your own life. It's clearly foreseeable that a mother in this situation could and would take her own life.
There's going to be a motion for mistrial very soon.
If we need to clean up that, I thought we had plenty of testimony on that. I can certainly put Jack on the stand right now and have him testify.
Judge, it doesn't matter. It doesn't matter if he shared that, which, by the way, was suggested by his attorneys.
No, these are two different
things. So the cause of action, and I think the plaintiffs deliberately are blurring these lines as much as possible because they know that they tried all different ways to get the suicide as part of this cause of action. What they are left with by this court's rulings is that there has to be an intentional infliction by the hospital directly to Beata. And there are...
Conspiracy is summary judgment out.
Yeah, conspiracy is summary judgment out. Their whole theme that they're arguing here is not in front of this jury. They want to try to get back in things that this court has already removed from this cause of action by trying to argue that intentional infliction on Maya is intentional infliction on Beata. And that's not the law. It has to be outrageous behavior to Beata.
I'm going to give everybody 2 more minutes. I'm going to take a 5-minute break and kind of sift through this in my mind, and then I'll come back and give a ruling. So each side gets 2 minutes. Plaintiff's going to go first. Go.
You got it? Okay.
The intentional infliction of emotional stress count that exists is for wrongful death. So this nexus is pled. We often hear that these things are outside the pleadings. This is what has been at issue in this case for a year or so. Would you like to add anything, Greg?
Yes, there have been 52 summary judgments in this case. This point has been attacked over and over and over again. They've wanted this count out since the first time that we pled it. And this court has taken that, has heard this argument on multiple occasions. And I get back to the fact that if you look at our cause of action as pled, and which was sustained over summary judgment and multiple motions to dismiss, we have alleged, and everything we alleged here, we have proven here. The essence for the court under the case law is whether the communication to Beata, both directly and indirectly, of the peril, if you will, the chance that her daughter would be either physically harmed, which she certainly was being, or would die in there, because you heard testimony from Dr. Kirkpatrick and from Jack about the leg embolisms, whether through the testimony from Maya of how she heard her mother's mood, if you will, her affect becoming flatter and more distant, and the testimony of Jack Kowalski that he was letting her know she was desperate for information. That's the testimony. He would come back and he would report back to her everything he could get out of Maya. She knew what was happening here, Judge. And so we do not see the law as it requiring Kathy Beatty to grab Beata by the shoulders and say, hey, I'm going to take your kid. That's not the way these things go down. Rather, it is the culmination of the knowledge of harm to the child with the intent to force Beata into some action that would, in essence, would separate them. And if that happened to be suicide, I don't think anybody showed any remorse about that.
You get 2 minutes. I don't care who argues, but
30 seconds, Your Honor. We've never settled on what an irresistible impulse is in this case. And the case law that I've given you has all indicated that it's something that someone does as a true impulse, that they're overcome at the moment and they decide sort of just quickly to commit a suicide. And what we have here is he's describing things that she thought this through and made an altruistic decision to save her daughter, an act that communicates with God about, frankly, that she's going to take all of these steps to do this elaborate suicide the following day because of an altruistic reason. That doesn't fit at all into the irresistible impulse concepts that have been in any of the cases that we've cited to you. This is a whole different thing. She made a very intentional decision to do this, and it's not that she was insane or driven to a point of exasperation. The other thing I want to point out is that all these things were this woman was in the hospital for a brief time in October, and that was it. We don't have all these facts that this doctor's relying on. I'll turn it over to Howard.
At 45 seconds left.
Number one, all of this intentional act conspiracy business is not proven and has been summarized out of the case. But number two, the most important point, the fundamental point plaintiffs come back to is that she was trying to get her child back. She was upset that contact was being denied. Those two matters were not within the control of All Children's Hospital. That's undisputed. There's no question that that was subject to the court. And that is the basis upon which this should be denied.
Thank you. I'm going to take 5 minutes and I'll come back and make a ruling. But I neglect, during the course of this trial, Ms. Lawrence, did you get your bar results back?
On the 23rd, yes.
And so you are now a member of the Florida Bar?
I am, yes.
Congratulations to you. I knew that you had been in the process, but I frankly had forgotten about the bar, been preoccupied by something else. But congratulations and welcome to the bar.
Thank you.
Okay, I'll be back in 5 minutes.
That's awesome.
All rise. Go to recess.
It's a very tense moment that they present that information. But congratulations, Miss Lawrence, on passing the bar.
Boy, that was pressure. I started my firm.
I was thinking this bar 48 years ago.
Oh no. Oh no. Okay, I've got Samantha on the phone. Hang on 1 second. Hello, Samantha.
Hi, boss.
Hey.
Good morning.
Good morning to you as well.
I just wanted to call in just to remind everybody about the hoodie up for grabs.
Yes.
And that their final submission should be done today.
Yes. We've got 730 some odd entries so far. If you would like to be in the running for winning the hoodie, you just have to guess how many total objections we're going to have, or how many we're going to have by the end of closing arguments. But your guess has to be in by the time that the plaintiff rests. So that's today sometime.
I just wanted to remind everyone, because we're bombarding them with the link in chat, and I just wanted them to understand the urgency of it.
Yes. So thank you very much for the reminder, Samantha. Today is the day. If you haven't made your guess.
Okay, boss.
Thank you. Bye-bye.
I'm back in chat.
All right. Bye-bye.
Bye, boss.
Samantha's amazing. One of our great mods. Appreciate her. Okay, I need to make sure that's not playing audio from there. Okay, good. All right. Yes, 80s Music Man hoodie is on its way to you. We got that sorted out. Hopefully, it takes forever to get there. It's going to take like a week and a half or so. But I apologize. I wish I could make it go faster. Okay, Dale Mox, the leaderboard idea. If Amber can send me the file, the document, or a copy of it, once it's all done, the spreadsheet, I may be able to make a leaderboard that I can scroll through. But anyway, let me share with you something I've got an issue with. I have to record another court case that is going on while this court is continuing. And it causes major issues that way. Oops. No. Stop. Where's my phone call? Hang on one second. Amber, you there?
I'm here. Go ahead and finish your dilemma for recording of a court case, and then I'll go.
I have to record a court case out of Adams County, Colorado, where the judge has given us a specific written permission to record their Zoom feed, or it's a WebEx feed of the trial. There's only a handful of people that he's granted permission to, thanks to Amber, by the way. We got our documents submitted in time and got approved on that list. So we have to record that so we can get that trial. That trial is not allowed to be live streamed, so we have to record it and then replay it or post it. So, and law and crime is under the same order that we are. So I have to get that video, and then I also need to have my live stream going at the same time. And I have equipment that can save that, but it records, it takes like, I don't know, 300 gigabytes a day to record it because it records all 8 feeds simultaneously. So I'm trying to find a way to do that. The system we're going to use what's it called? The leaderboard on is also a recorder, but it's not working. So I can't get it to record properly. It won't record from the device that I've got plugged in. I need one more computer is what I need to fix this. So I might have to run to Best Buy and buy a computer today, but to make that work. But anyway, that's my problem. Well, Amber, what's up?
Quick question. Can you not screen record it on like the iPad or something?
It's gonna be 8 hours of court. I need to record it in the highest possible format.
I would suggest breaking up the recordings, like when they do their 15-minute break and their lunch break, breaking it up. Yeah. So then it's not such a huge chunk of recording.
Yeah. Yeah, I've got to figure it out.
Well, let's you and I talk offline about that, because I may be able to do that. The only issue is going to be, how are we going to send you a file so big?
I'll pay for Dropbox. Yeah.
Well, I pay for Dropbox myself, so
you would have to be a subcontractor to legally record it. Otherwise, it would be like, contempt of court or something. I think is what it says it is. So I'd have to to pay you for doing it. Anyway,
let's chat offline and see what we can come up with.
Right.
The other thing the contest. So thank you so much, Samantha Terry, for calling in. Everybody loves hearing your voice, so you've got to call in more frequently.
She's far away. Just know.
She is far away. I saw a couple of people saying that they had that they messed up on their gas. I just want everybody to know there are several in the chat already who have heard from me and who have fixed their submission that they had a typo on. I am going through all of the submissions to make sure there's not typos on your guesses. If you have a 2-digit guess, or if your guess looks like it needed a 4th number, I'm contacting those people. So please make sure on your forms you're including the method in which to contact you, the details of that. Don't just say email, or don't just say call or text. I need either the email or the phone number to be able to get a hold of you to help you fix this.
Yeah, Cope and Whiskey. So this is Amber, who's on the phone right now. She's one of our great mods, and she's helping me run this this guess, the total objection count guess. We're going to do another contest as well. This is my first go at it, so I've pretty much made a mess of it. Thank you, Amber, for trying to pick up the pieces and make it work. But we'll do some more contests, and we'll give away some more cool merch. So
And just an FYI, you already have access to all of this data. You just don't realize it.
Yep. Yep, that's what I was saying. I just have no clue how to find it. All right, wonderful. Amber, thank you very much. Make sure everyone gets their guesses in. So,
reminder, it's by the time the plaintiff, the Kowalski family's case, rests their case in chief, you have to submit them by that time. But you're guessing for objections through the entire case through closing arguments for both sides.
Yeah.
So you need to give a total number of objections for the entire case.
And then what I'm going to do is I'm going to take the screen name and the guest number and put them in numerical order, which I think is fairly easy to sort. Export those into a text file, and I'll be able to scroll through like a teleprompter. So as we pass through, we'll see who's winning and who we passed and who's up next, and we can just see where everyone's at that way. So I can put that on the screen.
I'm so excited.
It's gonna be fun. It'll make the second half of court very, very interesting. So if we ever
Nicole,
get there,
that last is for you.
We're so close to a mistrial right now. It's crazy, but I think we'll get
nuts.
there. And if we ended a mistrial, obviously we're still gonna do the contest. We're still giving away the hoodie. So
I really hope it doesn't end up in a mistrial. I know they're going to appeal and the money's going to get tied up in appeal anyhow, but I really hope they've worked too hard for this case to go to mistrial at this point.
Yeah, I hear you. Amber, thank you very much. Appreciate you.
Not a problem.
All right,
I'll be in touch.
All right, bye. Okay, the judge just came back from Zoom. So we're going to come back from break in just a second here. I did want to say that this point is very crucial to including Beata's death in the liability. If they lose this point, that will sort of be excluded, and it will take a chunk out of any potential ruling or judgment.
Please be seated, everybody.
I think he's allowing it in. We've gone too far down this road for him to reject it. That's my take.
The question is in regards to Dr. Scott Richards and the proposed testimony. Previously, I had entered a in limine order that precluded him opining about standards of care of other physicians, and I maintain that order, and the plaintiffs are not challenging that. The question is whether Dr. Richards is able to give testimony and opinions relative to the intentional infliction of emotional distress, which there was one sentence in my order that implied that he could not. This morning I said that I think I made a mistake. Having listened to the arguments, I continue to believe I made a mistake on that. I find that Dr. Richards' testimony goes to the issue of wrongful death in the intentional infliction of emotional distress, and therefore I am going to allow his testimony in. Now, with respect to the defense, I know, again, I'm offering if there's, if you want to delay this testimony to give you time to prepare a cross-examination, I'm happy to do that, since I was the one that changed my ruling, and I certainly would offer that. We can tell the jury we can start in your case in chief, and then we can call back.
They don't need time.
I appreciate the offer from Your Honor. We would like to get this this witness done so the plaintiff can rest.
Now, with respect to, I don't know the terminology, but you suggest that you want to get into items that occurred in the dependency hearing. So I guess we need to talk about some of the boundaries, if you will. One thing that I heard you say, and if I'm misinterpreting, please let me know. And I'm certainly, one thing is you wanted to bring out the fact that there was still a final hearing that would be about a month later. And I think that concept is fine, that, the concept that, there was going to be a final hearing in the dependency court, a month later, I think that is not objectionable to getting into the sum and substance of the dependency. So I think that's okay. Now, with respect to the concept of Johns Hopkins Children's Hospital not being responsible for the shelter, I agree with that. And there was a comment that Dr. Richards made. There was a single comment that implied or maybe even expressly stated that the hospital is responsible for, right? Someone's going to have to talk to him to say that that issue is not allowable. Okay. So what were the other parts, Mr. Shapiro, that you wanted to get into that we can talk about?
Yeah, so Your Honor, we
And Dr. Richards still is not in our presence.
Whether I ask it or not, but we would need the court's direction. Can I ask this witness that one of the basis that upset Beata was the denial of a hug at the last hearing? I will tell you, I don't want to get into these issues, but I feel like I can't effectively cross-examine. And just to make the record, we do not want to get into the dependency action, but I feel constrained that we have to some degree in order for this jury to have the proper context that one of the reasons that Beata was so distressed is because Judge Hayworth denied her the ability to hug her child at the last hearing.
And is it your contention that that is what led or contributed Ms. Kowalski, Beata Kowalski, to die by suicide?
Yes.
Okay, you good? Judge, that has been their contention throughout this. I think that would be based on what his ultimate testimony is before this jury. I do not intend to get into anything other than Kathy Beatty's role in this in his direct examination. And the instruction is caused or contributed to, I believe, and not only at one level, but also the basic jury instruction in wrongful death. And in this is causation is this the only reason? Is it one of the reasons, substantial reason? So if they want to get into that, I object to it, obviously. I understand their position. It does open a lot of doors that I don't think need to be opened given this witness's testimony.
Your Honor, he in his proffer has already said that the irresistible impulse was brought on by the length of the proceeding, by the visitation issues, and by the fact that the trial was going on even longer for this hearing. He needs to say those things and then you need to say that none of those things are our fault. That's been his testimony. That's the basis of his opinion. The jury needs to know that's what his opinion is based on, and that none of that is our fault.
Yeah, and I know I've previously said, I've previously given the instruction. I said I'm going to give it again, and so that hasn't changed my mind. I'm going to again say that.
It's going to be part of my cross-examination if they don't bring it up on direct.
Besides the hug, what else? No, I'm asking the defense.
Yeah, one moment, Your Honor. I don't know if I'll ask it, but depending on the testimony, the fact that the hearing was pushed out at the request of the attorneys for the Kowalskis for continuance.
We don't agree with that.
Or rephrase differently, that the attorneys for the Kowalskis did not ask for an expedited hearing on this.
And I guess that...
Anything else?
That brings in Salisbury, he said.
I am going to ask him. I don't think this has anything to do with dependency, but I'm going to ask him about...
Well, anything having to do with the dependency, because I think that's where...
I understand.
If there's anything beyond that, Judge, we will approach the bench.
Yes.
Yeah, it's hard to say.
Okay, on the hug issue, if you ask a specific leading question, Like, isn't it true the judge in the dependency case on whatever day it was did not allow the hug? And whatever you want to say about did that contribute to the death by suicide? But make it clear that it was the dependency court and had nothing to do with the hospital. But it's a leading question. Mm-hmm. As far as the issue about the delay or the length of time of the dependency, I don't think that one I'm going to allow, because ultimately the dependency action was a very complex issue, and what the lawyers needed to get ready and all of that is, I don't want to get into those types of issues, and I think that really would be getting into the Chapter 39. So,
Judge, what about, can I ask, what about the fact that she was aware that there was going to be a final hearing in February?
I think I already said the final hearing was fine. So the hug is fine, the final hearing is fine. The question about a continuance / I think is not fine.
I understand you're on an all approach if there's anything else that comes up.
The continuance or the length, because I mean, by the book, this was supposed to be over as a dependency by December 9th, and it just didn't happen.
The continuance / length is not something that I think are appropriate questions.
But he's testified, and it's only rational that the length of the stay in the hospital and the length of this dependency proceeding are all interrelated.
But you're going to get an instruction talking about the fact that the hospital is not responsible.
Okay.
Anything else about the dependency action before? And someone needs to talk to Dr. Richards.
Oh, go talk to him.
He's on Zoom, so.
His phone,
well, what I'm going to do is I'm going to bring him in and say that you're going to call him, and then we're going to start. So I'm going to bring him in. Okay, Dr. Richards?
Yes, sir.
Okay, we're going to start in just a moment or two, but Mr. Anderson or Mr. Whitney is going to call you on the phone. I'm going to put you back into the waiting room while you have that telephone call with them. And then,
I had my phone off. Let me turn it back on. And is the lighting better in the room now for you?
No.
Actually, the light directly behind you is probably
worse.
A little difficult.
Really bad.
Is that better?
Well, let's turn him back on, and we'll just.
He's all the way in the dark.
That's the best so far.
Okay, I tried to adjust while I was away.
Thank you. Let's go ahead and have that conversation. I'm going to put you in the waiting room.
Thank you, sir.
Let them know we're like 5 minutes away.
Yeah, wake up the jury. Let them get, do their hair and get ready. All right, so we've Judge is getting memes on his phone, I think, right now. All right, so you detailed a Corvette for me this last weekend. I'm not even sure if I would fit in a Corvette. First of all, they seem very low to the ground, and they seem like they're not comfortable to get in and out of. At least nothing you can do gracefully. Although since I was a kid, I've always liked what a Corvette looked like. Never been able to afford one, or even had the opportunity to sit in one. All right. Let's see. We're going to brang the jury in just a minute as Mr. Anderson is instructing the witness what to go into and what he can't go. Well, what he can't go into. This witness is flirting on a very dangerous line. They're dancing on this Title 39 issue. The judge has allowed a very leading question on cross, and they're allowed to lead on cross. But I think even if it were on direct in this situation, he would say, "I want a very leading question. Yes, no, did this occur?" This very specific. So they need to form that question exactly as the judge said. They will get the testimony out of the witness that there was this denied hug at a dependency hearing. And that was by the judge. It had nothing to do with the hospital. That's going to be in there. But the testimony that this doctor, this individual gives, I think is a doctor, is really going to be damaging because it does tie Johns Hopkins All Children's Hospital to Beata's passing. and as a causation. And so I think the judge ruling this way gives us a understanding that when, and I say when because it will happen, as soon as the plaintiff rests, defense, Grandpa, as you guys were calling him, the kind, wise man in the back of the room, the attorney, will make a motion for a directed verdict, and it's going to have a lot of different parts to it. But he's going to ask for a directed verdict on this charge, saying that they never proved that. There was no evidence presented to the jury could consider to determine if that had occurred. But the judge ruling here sort of gives us a preview into his mind, saying yes, there really was, because he's allowing it, and he thinks it speaks to that. So it sounds like this is a big win to at least get this in front of the jury. Now, if there's a mistrial between now and when the jury starts deliberating, that's all goes for nothing. But that's where we are. All right. Have an easy day. Say, I owned 3 Corvettes in my lifetime. Loved them all. Corvettes prior to 82 and the new C8s. I saw one of the new ones actually yesterday driving around town. Convertible. Looks, it's a flashy car. It was a flashy car, and the gentleman driving it looked like he maybe took it up to 40 miles an hour once. Okay, so he was very, very gentle with it. He was driving on a road that had a lot of potholes though, so maybe that's why. Okay, Dusty Den says all the outsourcing J-Hatch did and the involvement of family services is making me nervous for defense case and their technical liability. I think they've got a lot of. Defense is going to be difficult because they've set up so many landmines for the plaintiff that now they have to walk through that same field, and they're trying to also bring in additional information walking through that same field, and I think they're going to step in it, and really that will open the door in some way. I don't see how we can get through this without opening the door somewhat to things they don't want to. And for specifics, if they get into this court hearing, you heard Mr. Anderson say it, that opens the door for Salisbury, the letters, or Salisbury, the letters from the attorney informing the hospital of something that was going wrong. So I think we're going to see that today as well. Let's see. Have you ever wrapped a TVR? That was my sports car in England. Let's see. I think the only sports car I drove in England was a Lotus Elise. Which I should not have been driving. Let's see. Start a GoFundMe to get me a vet. You could put your logo and name on it. It would have to, for it to really be effective for the channel, it would have to be fully outfitted with cameras and streaming gear so I could live stream from inside the Corvette, which I'm not sure is safe. Let's see.
Mr. Shapiro, I think, had one more topic he wanted to ask about.
I would like to ask this witness whether he was aware that from the date of shelter, which I believe was October 13th, 2016, until Beata's death by suicide, that the court ordered no physical contact between Beata and Maya, and that never changed.
I do not want to get into anything having to do with those orders or the specifics of them, because it makes on redirect a lot of issues open up that shouldn't be opened up. I'm sure that the order or the jury instruction, whatever, will make these things plain, but I don't think that's a good one for cross.
But I've already said that I'm going to have an instruction that talks about the times and who and what was permissible as far as conduct. So that specific question, so long as it's a leading question.
We'll be leading.
It's fine.
And I just want to ensure, I know that Mr. Anderson had a short call with the doctor, that the only thing they discussed was about one issue that they didn't want in, and that we're not going to see a wholesale change of his testimony from what was seen on proffer.
No. The one thing I told him to do was he should not get into length of stay. But most of his testimony was about Beatty anyway. So.
Well, that's
this is the problem with proffers, Your Honor. Without getting deep into it, we've seen what his anticipated testimony was. I plan on committing him to that testimony. So
they're the ones that asked for it. So. All right.
We ready to bring in Dr. Richards?
Yes.
Okay, let's bring in the jury.
Okay, so now defense is saying we want him to testify in what he talked to before. So Plaintiff is not going to elicit that testimony regarding length of stay. Defense says we're going to bring it up on cross, and now plaintiff is saying if you bring it up on cross, Salisbury letters are coming in. So this is going to be a fun little fight. I'm not sure if the judge is on board with the Salisbury letters because he's ruled against them several times. Okay, jury's coming into the room for the first time today. They haven't heard anything. It's 10:14 now.
Okay, please be seated. Happy Monday.
Happy Monday.
And just to let you know, a member of the National Labor Relations Board will be here on November 10th. Only asking for 10 minutes? I would have held out for more.
They sent a note.
I appreciate the note, but let's go ahead and transition to while we're here. I want to confirm that while you're away, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that all correct? And since you were last with us, have you been approached by anyone about this case? And have you seen any media coverage about this case? Okay. Now, our next witness is going to be by Zoom. I have, just so you know, outside of your presence, already administered the oath to this witness. So that has already been done, and he will be testifying under oath. Okay, with that.
May it please the court. Please state your name for the record.
Scott Burgess Richards, MD.
And are you a psychiatrist I have called and asked to render opinions regarding the reasons for Beata Kowalski's suicide?
Yes, you have, and I am.
Can you give the jury the benefit of your background training and experience towards offering opinions here today, beginning with your undergraduate degree?
My undergraduate degree was received from Marshall University in 1982, and I was honored to graduate with summa cum laude honors with a degree in psychology and history and a minor in biology and chemistry. I then proceeded to follow my father's footsteps and go to Temple University in Philadelphia for medical school, where I spent 4 years training. Subsequently, I decided, much against my orthopedic surgeon father's wishes, to become a psychiatrist, and subsequently enrolled at the Medical University of South Carolina for my internship, a subsequent residency in psychiatry, and during that time, I enlisted as an officer in the United States Air Force as a captain. And because of that, during my final year, I was able to complete a fellowship in eating disorders and mood disorders while being the clinical chief resident at the Institute of Psychiatry on the inpatient unit.
Now, go ahead, please.
Subsequently, I was serving my United States Air Force time. I spent 2 years as an active duty psychiatrist performing at March Air Force Base. And during the first Gulf War, we had a manning assistance issue. I was subsequently sent to Minot Air Force Base in North Dakota. And I can say for a Florida and California-based person, that was a difficult couple of months in February and March and April. During that time, I was tasked with taking care of the nuclear force there at Minot Air Force Base, consisting of the nuclear personnel that were in the silos as well as their families. Upon finishing that, I left the Air Force in 1992 with an honorable discharge and multiple awards, one significantly that we were the first military hospital to treat civilians. So we began to take Champus patients at March Air Force Base and received a commendation that we saved significant amount of money for the military. Upon leaving, I was recruited by an institute in San Diego, as my wife at that time was a researcher in science, and she received a degree and a job in San Diego. So I took a job with Alvarado Parkway Institute as a staff physician, but I also had a private practice at that time. During that, I had children and decided they were more important. Plus, I have a lot of avocational activities, and I decided to take a job at the county mental health as a senior psychiatrist. I've always been interested in indigent care, and I did not like working for money. I felt that we should take care of patients. During that time, I was recruited by Kaiser Permanente to become the head of their eating disorders division and write their protocol. And I subsequently spent approximately 17 years as a full partner in the Kaiser Permanente Southern California Permanente Medical Group. Upon my children growing up and me not wanting to be in California anymore and wanting to go back to my Florida roots, I moved back to Florida in approximately 2014 and took the position as senior psychiatrist at New Horizons Health Center in Port St. Lucie. At that time, I was the director of the Closerville Clinic. as well as running part of their inpatient psychiatry and outpatient long-term care. During that time, I received approximately 300 or 400 phone calls from locum physician providers who wished to have psychiatrists travel around the country. And I learned at that time we had approximately 11,000 unfilled psychiatry jobs in small towns around the United States. I was talked into going to Pocatello, Idaho, which I would never thought I would do.
Yeah, don't do that.
And I almost moved there after 10 months of working 2 weeks on, 2 weeks off. I developed their program. They now have 2 psychiatrists working there. I've gone back once. I've worked in Lewiston, Idaho for approximately 7 months. I've been at the University of Indiana, and I'm not sure I can put all the other places, but I've been doing locum tenens work, providing care for smaller to mid-sized communities. I had to take some time off during COVID for a severe fracture of my right foot, and then a year later dislocated the same ankle. Last year, I went back and provided approximately 5 to 6 months of care at the Myrtle Beach, South Strand, and Grand Strand hospitals. And I'm waiting to take a new locum position pending the ending of this case, as I've spent a significant amount of time. And most hospitals don't want to hire somebody and then have you leave for a few weeks for testimony. So at the end of this trial, I'll be getting a new locum position, possibly in either South Carolina or here in Florida.
And where do you live right now?
I live in Port St. Lucie, Florida. I established a residence there approximately 9 years ago.
And you and I have known each other for quite a while.
We have known each other. We've known of each other for approximately 50 years. We ended up becoming fraternity brothers at Duke University, where we swam together, where I was the first 2 years of my college. Unlike you, I left after they fired our coach, and I transferred to Marshall University, where I completed my academic and athletic career and proudly became an all-conference swimmer my last year.
Well, in the
unlike you, I left
interim,
when they fired the coach.
Not the interim, but after that, from time to time, have I called you and asked you to review different cases, not necessarily medical malpractice or anything like this, but a variety of cases for your acumen on medical issues?
Yes, actually, I can recall, and I was just reviewing on my flight up to Pennsylvania this week. Our first call, I believe, was when I was a senior fellow and you were a young associate. You had called and asked me to review a medical record, and that established a pattern. Approximately every 2 to 3 years, if you had a case that had medical issues, you would send me the records and ask me to review the records. One thing I do want to emphasize is that we established an agreement that you would not let me know who you were defending or prosecuting. You would just send me the medical records to review, so I wouldn't have any bias. And that was very strong, in my opinion, if I was going to work with you in the future, that it needed to be a non-biased presentation. And I pride that I've continued that with you throughout the last 30 years.
Now, have you, so you're licensed in which states?
I am licensed fully in 6 states right now in the United States. I believe Florida, South Carolina, West Virginia, Indiana, California, and Idaho. And I do believe that Idaho also has on request reciprocity with Montana and Wyoming because they have so few psychiatrists. You are easily able to be re-licensed in those states as part of a Western state pack.
And you're board certified?
I am board certified since 1993, fully certified by the American Board of Psychiatry and Neurology, of which consists of 70% of our exams are psychiatry and 30% neurology. Neurologists would have 70% neurology and 30% psychiatry.
And I understand that you are certified, you have been certified as a disability examiner by a number of different states and organizations, including the federal government and certain state governments.
Yes, back during my residency, I was fortunate enough to be able to have a somewhat locum job before I joined the Air Force and started doing disability evaluations for the VA. Subsequently, when I got into my private practice, I was approached by a disability firm because they knew of my background and did approximately 500 to 700 disability evaluations over the course of approximately 7 to 10 years. So, continued during my job at Kaiser Permanente, I would also do disability evaluations as they knew that I had done them in the past. Therefore, a number of the physicians would refer to me patients who needed disability statements or evaluations.
So now, turning to the issue at hand here, if I understand it, then you have in your practice continuously had issues regarding threatened suicide, suicide ideations, unsuccessful suicides?
Throughout my career, being an inpatient psychiatrist, what you tend to treat is the people who are acutely ill. And because of that, I would say approximately 30% of the patients that we admit to inpatient facilities tend to have suicidal ideation. They've had suicide attempts, and therefore I have had significant experience in addressing and assessing suicidality. I have had a few patients that I've needed to do postmortems on. I'm lucky enough to say I think I have only had 2 patients in 35 years actively commit suicide, and I will say one of them, I was away on vacation. I'm not sure I can take credit for that one.
All right. And so if I'm understanding correctly, you have evaluated the issue of suicide for the Air Force in that capacity of evaluating military and I guess missile crews. Is that right?
Well, in the Air Force, when you're an inpatient psychiatrist and an outpatient, you are responsible for the mental health of all active duty personnel to make sure they are ready for action. Therefore, one of the things we do in every evaluation is to assess for potential harm to self or to others. So when someone asks about whether I evaluate for suicide, I think every psychiatrist should evaluate for suicide in every single visit.
Were these guys, by the way, the guys with their fingers on the button or turning the key? Yes. For
they were in the silo with the keys on the button. There are certain things I cannot speak about because of confidentiality, but I was able to tour the silos, and yes, these are people that have high security clearance.
All right, and then you worked for
I almost went to work,
for lack of a better term, public medicine in San Diego for a while. Is that right?
I was the chief psychiatrist at the downtown mental health center that treated indigent patients from approximately, I was there part-time in 95, and I was there until I joined Kaiser Permanente in 97. I continued to do some consulting for them over the years.
And how long were you at Kaiser? So Kaiser Permanente was a hospital job for you?
Kaiser Permanente is the largest health maintenance organization in the United States. They're massive in California. They own their own hospitals. They own their own outpatient, their own pharmacies. I started off as the director of their eating disorders and had an outpatient practice. As part of it, I covered the hospitals approximately once a month for the weekends and during the week. And then approximately every 4 to 6 months, we would also do inpatient consultations. I want to stress that my work as locums has led me to do a lot of inpatient psychiatric consultations. I spent a lot of time on the medical units. Because of that, I've spent the last few years doing a lot of continuing education on medical issues. In my opinion, it's very important that every psychiatrist makes sure that medical illnesses need to be addressed first before you make a psychiatric diagnosis.
And have I asked you to review your records to determine approximately how many different psychiatric cases that would include suicide cases, including ideations, meaning, or plans, or attempts through the course of your career?
Can you ask the question again, please?
Yes. How many people involving suicide have you examined and or treated?
Throughout my career, I would say I've assessed approximately between 12 and 15,000 individuals, and I would strongly say that I assess for suicidality in every single one of those patients, especially on the initial visits, and at least the first 3 to 5 follow-ups to establish a relationship with the patient.
And as part of that, did you regularly form opinions as to the specific and general causes as to their suicide attempt, and what is an ideation, by the way?
Ideation is the thoughts in your head that potentially self-harm is an option. So you're thinking about it. And in terms of the causes, we talk about risk factors for suicide. I'm not sure we can say cause specifically, but the term risk factor is very important when you're assessing for suicidality. You look for things such as family history, genetic predisposition. You look for past attempts. You look for any substance abuse issues that are significant. You look for intrusive stressors on a person that will place their defense mechanisms at a stress level that would cause them to then be overwhelmed.
And so what have you reviewed in connection with offering opinions for the jury here today, if you could give us an overview?
An overview would be the best way to say it, because I first received medical records to review on this case approximately 5.5 years ago, and at that time I had at least 3.5 feet of medical records. Over the ensuing 5 years, I believe I have reviewed a few thousand pages of depositions. I have reviewed the auto medical records. I've reviewed Maya's hospital records. I had a brief interaction with the family early on, not clinical, just meeting them almost in an accident when I was visiting you at an occasion. And through that, I've reviewed, I would say, approximately 5,000 pages throughout this case.
And have you had the opportunity to meet Maya on more than one occasion?
I've met Maya on approximately 4 or 5 occasions, I believe, over the last 4.5 years.
All right. And so what, if anything, was significant about, Beata's history, if anything, that was pertinent to your analysis and opinions here?
There was many significant things in terms of looking at the case from your request in terms of her suicide. I can start off with her upbringing in communist Poland, and I feel that I have a little more insight. I was able to visit there in 1975 for approximately 6 weeks and got to experience times during the communist regime.
Your Honor, I apologize for the interruption. Objection to the relevance.
I'm going to sustain with respect to the doctor's experiences in Poland.
It's all right. Just let's talk about Beata's experiences in Poland.
When I reviewed her history, there were three things that were significant to me in terms of looking at past events that might have caused a characterological development. The fact that she did grow up in a somewhat oppressive regime, I think, is important, and that people tend to feel somewhat constricted and controlled. The other aspect that I learned recently by watching the interview of her sister, that her father was taken away during the Solidarity movement, also reinforces the sense of lack of control. And she also grew up with a strong Catholic faith, and we have learned that the Catholicism tends to be a somewhat rigid and strict. So therefore, this is a woman that grew up with the idea of right and wrong. It appears that she had somewhat strict, rigid rules in her head. She was very driven in terms of her academic performance. I think those are factors that I reviewed in terms of her upbringing. I do feel that the loss of her father at a young age, the fact that her mother left, being raised by a grandmother who obviously would have grown up in significant communist times may have been a factor. And then moving to America was a significant issue. You come to America with no language capacity. I think that's an amazing stressor, and it shows the will of a person. I've also reviewed some of her writings, and I see a cogent, linear thought process that is appropriate. The other aspect is she is
non-responsive, Your Honor.
Overruled. You can continue.
Go ahead. You may continue on the writings.
I've also viewed that she was a nurse by trade, and to me, psychiatrically and on a psychological basis, that is important, in that most nurses tend to be somewhat altruistic in their work. They tend to want to do for others. They don't want to be the doctor. They want to be the one that cares for the person who in a sense, implements the orders of the physician. So that is an important factor, in that a Catholic-based woman who is structured and rigid about doing the right thing, in my opinion, and doing what I call a post-morbid and post-mortem psychological evaluation, it was consistent for her to go into nursing and be a caregiver in light of her upbringing.
What about Beata's psychological history? Did it come to your attention that she had sought counseling during a period in 2015, 2016, after Maya was diagnosed with CRPS, before and after Maya was diagnosed with CRPS?
I think that's an excellent question. I reviewed that, and my approach to this was, here was a woman who was placed in a situation with a daughter that she did not know what was going on. There were significant medical problems, and I found it very appropriate that she sought out supportive help and care to be able to process the significant emotions she was obviously experiencing at the time with her daughter being ill.
All right. And so now, having armed with that information and analysis, can you tell the jury then, looking at Beata's experiences in those months leading up to her suicide, the influence of different factors, but in particular, if it is your opinion, the influence of her daughter's treatment at Johns Hopkins Children's Hospital?
Can you repeat the question again?
Sure.
Good question.
Right. I'm looking for how she got to where she was. I'm looking for your analysis to the jury of what brought Beata to the point of suicide, and I'm particularly interested in those last few months at Johns Hopkins Children's Hospital and how her daughter was being treated.
My approach on this was to look at those causative factors, as we said. My opinion on this is that I saw throughout the course of the events from 2015 all the way to her demise, the ability to keep control over her life, the ability to keep control over the health of her children was gradually being diminished. And I do feel strongly that the events that occurred during the hospitalization, the early hospitalization specifically, that she had total control taken away from her in a variety of areas of her life. She had her personal life taken away. Her professional life was challenged. She was threatened with potential legal action. She was accused of things doing to her daughter. She had her integrity challenged. She had her marital situation apparently challenged at some point by the hospital to her husband. She was unable to touch her child, see her child. She had limitations on her ability to control her world. When we lose control of life, we cling to our defense mechanisms to get some kind of control back. And in my opinion, she used every defense mechanism at her fingertips. She utilized friendships. She utilized her husband. She utilized her church. She utilized everything she could. Situations such as the priest not being allowed to give the sacrament. She even wanted God to help, and God wasn't allowed in the room. That's an overwhelming situation for someone with her religious background. I feel it got to the point that she suddenly had an impulsive behavior, and I use the term altruistic surrender. We have altruism in our life. We do things for others without wanting something back. But altruistic surrender is a different entity. It is where you do something for others without any thought of yourself, and in fact, you discount any harm to yourself. And I believe that the impulse that happened for Beata was she suddenly had the impulse of, I can do no more. I've gotten everyone in my life involved. No one can seem to help. I'm going to make a deal with God that I'm going to put myself in front of the bullet, in a sense. What we call Sophie's choice, I think in the movie, where she had an untenable decision to make, and impulsively she made the decision. I liken it to someone who is impulsively having emotions. They write an email and they hit send and they wish they wouldn't have sent it. In this case, there was no delete. We couldn't unsend the result of this impulse.
All right. Now, can you explain to the jury then, and assume for the purposes of this question, that Beata had knowledge of Maya's treatment there by hospital staff, in particular Kathy Beatty, and also that Maya's CRPS was becoming gradually worse over this period of time? Can you address for the jury the instincts, the mammalian, the human instincts that may have played a part here?
Objection, foundation, mischaracterization, and compound.
Okay. I want to agree on compound, and I didn't totally follow your question anyway, so.
I don't think the witness did either. let me rephrase that. What, if any, effect did instinctual behavior have on Beata in this path towards a suicide?
When we talk about instinctual behavior in context of this case, I think we're talking about the maternal instinct for protection. And over the course of the last few months, as you and I discussed this, I did a significant amount of research on the topic of maternal instinct and was surprised to find over 50 years of both animal and human research.
That's the bolster, Your Honor.
Sustained.
You can just tell us from your background, just from your experience and knowledge, we can't bring up specifics of study. But go ahead.
My experience and knowledge has shown that significant changes happen in the human behavior that cause the maternal instinct to be manifest. And this is shown even during pregnancy. I have seen behavioral changes, and we are documented that even aggressive changes and erratic behavior can happen when the maternal instinct kicks in.
This is the tigress for the cubs type of behavior?
It's actually, we see it in higher primates as well. We see it in humans, but it's in the animal kingdom everywhere. The idea of protecting your pride,
your offspring,
at the expense of yourself is common throughout the animal kingdom.
And is it your opinion, to a reasonable degree of medical probability, that the maternal instinct had a significant effect on Beata impulsively taking her life?
Yes, it is strongly my opinion that the maternal instinct was a significant factor in the ultimate demise of Beata Kowalski.
And so leading up to this, I'm sure that we can discuss a number of different factors, but in terms of that evening on January 7th, 2017, that night, can you take the jury through the reasons why, and then I'll ask the big question, but the reasons why you believe ultimately that this was from an irresistible impulse to commit suicide?
Can you phrase question again, please.
Sure. I'm talking about in those last few days, the day or even the evening leading up to Beata's suicide. Can you explain to the jury how those facts led you to a conclusion, opinion, if it is your opinion, that Beata's suicide was a result of an irresistible impulse to do so?
Understand. When I began to address the significant stress factors that accumulated over the period of time, I believe in the last 48 to 72 hours, Beata had exhausted every defense mechanism she possibly could. And when human beings have exhausted their defense mechanisms and they have no alternatives, the mind begins to race and impulsive thoughts begin to enter. This is usually when we see people in our emergency room when they get that way, but usually it's after the attempts have happened and we find them in the intensive care unit. In my opinion, what happened in this case is the factors in the last 24 to 72 hours of Beata Kowalski's life were so overwhelming that her defense mechanisms allowed nothing other than an impulsive behavior.
And was a significant, if not major, the major part of this, learning the full extent of Kathy Beatty's treatment of her daughter?
It is my very strong medical opinion that the information that a parent would learn about their child is a significant factor for Beata Kowalski's suicide.
Do you have an opinion based upon your background, training, and experience, and to a reasonable medical probability, as to whether Beata Kowalski's death, her suicide, was a result of an irresistible impulse to do that on that evening?
I do, and I believe it was an irresistible impulse of suicide.
And then do you believe that Beata Kowalski's perception of the hospital, particularly Ms. Beatty, others' treatment of her daughter, was a substantial factor in creating that irresistible impulse?
Absolutely, yes, I do.
And therefore, do you have an opinion based upon your background, training, and experience as to whether the hospital's treatment of Maya was a substantial factor in bringing about her suicide?
It is my professional opinion that the treatment of Maya Kowalski was a direct factor in the causative effects of Beata Kowalski's suicide.
And so in terms of the transmittal of information, did it come to your attention that Jack Kowalski was providing Beata updates every time he saw Maya on exactly what her physical, mental, and emotional condition was?
Yes, it is my understanding that Jack was communicating with Beata on a regular basis, as he was the only conduit that she could get. And he would be that person. So yes, it is very strong that Beata would have that information. In fact, to get it secondhand is even tougher because you're not able to get this primarily, and that's even more of a loss of control.
But did it come to your attention that Beata also had direct contact with the hospital, particularly Miss Beatty, through attempts to speak to her daughter on the phone?
Object to the leading, Your Honor.
Overruled.
You can answer.
You can answer.
Yes, I am aware. I have reviewed some of those recordings, and I'm aware that Ms. Beatty was present during the phone calls.
All right. And did it come across to you in any, well, strike that. And
scratch all that.
Let me, for the purposes of this question, and I don't know if I have advised you of this or not, but that Maya Kowalski has testified that through knowing her mother, hearing the sound of her voice, and as the time in there approached her suicide, that her inflection, her tone, her flatness, her inability to find questions indicated to her that her mother was on a road to suicide. Did that, would that add to or subtract from your opinion? Or is that another question I need to ask again?
I think if you could ask in a different way, I'm not sure exactly what you're asking on this question.
You know what, I'll withdraw. Did it come to your attention that after Beata's suicide, that there were certain communications between and among physicians at Johns Hopkins All Children's Hospital that indicated that Beata's suicide was actually contemplated by them?
Objection, relevance, and foundation in the time frame.
Sustained.
In the period immediately after Beata Kowalski's suicide. Did it come?
Overruled.
did it come to your attention that certain members, physicians at Johns Hopkins All Children's Hospital communicated about an expectation that Beata might take her own life?
Same objection.
Yes. I'm aware of that communication.
Okay, the court overrules the objection. The answer stands.
Wow.
Nick, do you have anything else on that? Your witness. Thank you, doctor.
Okay, now the defense is going to go in and ask about these.
Yes, sir.
The dependency hearing. Very carefully worded question. Let's see how they do.
Good morning,
that.
doctor.
Good morning.
Just to cover something I think I heard you say, you're personal friends with Mr. Anderson?
We've known each other. We've known of each other early on. We have been friends for an extended period. We live apart, but we keep in contact on a semi-regular basis.
You've been friends since college?
I would say more friends since after college. During college, we did not run in the same social groups at all. It was after college that he took law school near my home, and he actually became more friendly with my parents at that time, and we developed our friendship post-college.
You were fraternity brothers?
Our fraternity was large, and as I say, my example is Mr. Anderson listened to Jimmy Buffett, and I listened to progressive rock. We lived in different worlds.
I won't comment on which one's better, but just, but in all, this is a serious issue.
I understand.
You did not, you don't see this as a conflict of interest reviewing cases for your friends, do you?
No, I have actually done professional work. And when we first discussed this many years ago, we made sure that this would be professional only, so that I made sure that things came through his office. They did not come through just the mail. Things had to come through the requests. And in fact, this case came as a request through his office in May if I would review medical records.
How much have you charged to get here today? From the inception of the case, what are your fees in this case?
I have charged, I believe, over the 5.5 years, I think I've charged approximately $11,000 to Mr. Anderson's office, and I believe your office paid me approximately $900 or $1,000 for our deposition a year ago. The rest of the time, I have been doing this without charging Mr. Anderson at this time, due to my strong convictions about the issues in this case.
I want to talk to you a little bit. You talked about irresistible impulses, but I want to talk to you a little bit about alternatives to suicide. Okay, doctor?
Mm-hmm.
You are aware there were multiple opportunities for the Kowalskis to have Maya transferred out of All Children's Hospital. True?
Yes.
You are aware in fact, you are aware, are you not, there was a final hearing to determine the outcome of Maya Kowalski's case.
Here it is.
Beginning on February 21st, 2017, where if the Kowalskis could have proved their case in the dependency court, Maya would have been sent home. True?
I believe that is true.
If you are aware, well, let me back up, because this is very important too. The jury heard from Dr. Kirkpatrick on Wednesday that he advised Mrs. Kowalski that if Maya didn't receive his medication, she would die, Maya would die a, quote, slow, painful death at All Children's. Are you aware of that?
I'm not aware of that exact statement.
Okay, well, I'll represent to you that Dr. Kirkpatrick took the stand on Wednesday and told this jury that he told Beata Kowalski that if Maya didn't get the treatment that he recommended, she would die a slow, painful death.
I do remember actually him saying that she had a significant higher risk, but I'm not sure I recall him saying she directly would die.
Okay, well, the jury has their notes on his testimony. Are you aware that as part of Beata Kowalski's suicide note, she specifically quoted him that the failure to get his treatment worried her that Maya was going to die a slow, painful death? You're aware of that, true?
Yes. Yes, I am.
And you're aware Dr. Kirkpatrick was wrong, correct?
Objection.
I'm not sure I can answer that question.
Sustained.
Okay.
Yeah, this is getting way big.
Well, let me go back to the dependency court, and let me ask you this question.
That was a
in terms
very
of the
inappropriate
sequence
question.
of events, you are aware that the judge in the dependency action ordered Beata Kowalski to have no physical contact.
Excuse me, Your Honor. We need to approach on that last question. I think we may need.
Well, on this question is what we've already talked about, and he's allowed to ask the question.
Oh, the last one.
Start again.
I will, thank you, Your Honor. You are aware that the judge in the dependency action ordered Beata Kowalski to have no physical contact with Maya as of October 13th, 2016. True?
Objection.
True.
Beyond the scope of the order.
And members of the jury, I just, again, want to let you know, before this trial is over, I'm going to give you an instruction about the timing relative to contact and when it was and was not allowed and all that. You will get that before you deliberate. So just to let you know that is coming.
Okay.
You may continue.
Yeah, and just to make sure the jury understood that, you are aware of that, correct, Doctor?
Yes.
That certainly caused tremendous stress on Beata, did it not?
It was a stress factor, yes.
Well, I think you talked about the ultimate stress on Beata was being separated from her daughter. True?
Not sure I called it an ultimate stress. I would not use that term in my profession. I'm not sure anything is an ultimate stress. Stressors are individual, which can be perceived differently by individuals. So I would never use the term ultimate stress.
The no physical contact between Beata Kowalski and Maya that started on October 13th continued until the hearing in front of the dependency court on January 6, 2017. True?
True.
This is now almost 3 months that Beata has been physically separated from her daughter per order of the court. True?
That is true.
You are aware, are you not, Doctor, that at that hearing, the judge denied Beata the opportunity to hug her daughter. True?
True.
So for this period of separation, Beata was unable to touch and see her daughter in person. True?
True.
And within 48 hours of that, Beata took her life. True?
True.
And she took her life to end the separation of Maya from her family. That was her motivation, to get Maya home. That's what you just told this jury. True?
It was one of the factors in her suicide.
It was what you described earlier to me as an altruistic surrender to bring Maya home. True?
True.
One moment, Your Honor.
Okay, so that flirted with that line for quite a while. Let's see. I think it's Mr. Anderson's turn now.
I don't have any other questions at this time, Your Honor.
Any redirect?
Dr. Richards, did it come to your attention that Dr. Kirkpatrick also testified that Beata knew all about the leg blood clots and the potential harm to her daughter well before he ever said that to her?
Yes, that is true.
And that, in fact, she brought up the topic of how long and what the threat was, not so much how long, but what the threat was to Maya Kowalski if her physical state got to the point where she could not hold herself up and basically had to lay in bed.
That is true.
And is that, in fact, a danger, by the way, for children and adults in that situation?
Objection outside the scope foundation.
Sustained.
All right, we'll move on from that. Also, in terms of Beata's suicide, then there were multiple different, if you will, factors involved.
Yes.
The majority of those factors came from Johns Hopkins. Is that true?
Absolutely true.
Anything further, Mr. Shapiro?
One moment.
Okay, guys.
One moment, Your Honor.
We're running out of moments to enter your guesses if you're wanting to enter the contest for a hoodie. How many total objections will we have by the end of closing statements at the end of trial? You have to get the guess in before the
Don't go anywhere,
defense.
Dr. Richards. Members of the jury, the jury has an opportunity to ask questions, and so they're writing out their questions. So just give us a couple moments.
Thank you, Your Honor.
Each side does have 55 hours, and beginning this morning...
My water cup real quick?
Yes, sir.
Thank you.
Beginning this morning, the plaintiff had used 43 hours, 35 minutes. Defense had used 14 hours, 45 minutes. They've been using about 3 or 4 hours on the plaintiff side each day, and 1 to 2 hours, right on an hour each day for a little under an hour each day for defense is the average. I don't think the defense argument impacted the jury as much as I think they hoped it would. Remember, your guesses have to be submitted on the form. You can't. Oops, sorry. Let's turn that off. We can't use chat to submit your guesses. They have to be submitted
Dr.
on
Richards,
the form.
I'm going to mute your audio feed.
Do we kick the jury out? Nope, jury doesn't appear to be kicked out. Okay, all the audio feeds are muted. The cameras are... I can see Dr. Richards still on the screen. Cameras are pretty much obscured by suits right now. We just have the judge's robe and a bunch of suits visible on the Zoom window. So you have to submit your guesses on the form. I think we've got 700, close to 750 guesses in right now. Guess in chat is not going to help. We can't help that way. We can't track it that way. We need to submit it on the form. So click the link if your message got deleted, or if you put it in chat, make sure you click the link. This link that's in the form, you have to go over to the chat and click that form. It's a Google Docs link. That's how we're going to track it. We have over 800 submissions. That's awesome. We're going to have to do some more contests. Lauren, if I were that audio guy, I would definitely bring my own seat cushion. Wish we could see what these questions were. I hope they all get asked. But you know that there's going to be, especially because the defense was able to ask about the separation, about the dependency. You know there are going to be questions that are related to that cannot be asked in this case. Gordon says, I go away for 3 weeks. RA has another goatee and we have competitions. Welcome back, Gordon. Good to have you back. Carolyn, it depends on the number of winners. If we have like 15 winners, I can't send out 15
Dr. Richards, I need you to turn back on your microphone. Can you hear me now?
Are we working okay?
Yes, can you hear me? Okay, great.
Is the lighting better, by the way, too?
Perfect, thank you.
Worked on it a lot in between, so.
We'll make a lighting director out of you yet.
Oh, don't go too far.
The judge already is a lighting specialist.
First question from the jury. Do you believe that Ms. Beatty's interference in the phone calls was one of the leading causes for the breakdown of Beata Kowalski's sense of control?
Ooh.
Absolutely.
Boom.
Next question.
That's a plaintiff question for sure.
In your testimony during cross-examination by the defense, you stated that you were aware that there was an opportunity for Beata and Jack Kowalski to transfer Maya out of Johns Hopkins All Children's Hospital. Do you know why that transfer/release opportunity or opportunities were not accepted?
Yes, I do know.
Okay, here's the next question. If you knew why Beata refused the transfer, was the transfer diagnosis a contributing factor to Beata's suicide?
Absolutely.
Okay. Mr. Anderson, do you have follow-up questions?
if I were Johns Hopkins All Children's Hospital insurance provider, liability insurance provider, at this point, I would be looking at raising my rates. It's that question. It was yes, holy buckets, says Mindy Lou. Yes, it's wow.
One last question. Having heard all of the questions here, where am I? Used to going over there. Having heard Johns Hopkins questions, do you stand by your opinion that Johns Hopkins and Ms. Beatty's maltreatment of Maya was a substantial factor in Beata's suicide?
Yes, absolutely.
Thank you.
Briefly, Your Honor.
Mr. Shapiro.
Regarding the interference in phone calls, certainly if it was not Kathy Betty's voice on the phone, she would not be a factor in the interference. True?
Please ask the question again. I'm not sure what you're asking.
Well, I'm trying to ask you whether you know whether that was actually Kathy Betty's voice on the phone conducting the so-called interference. Do you know?
Objection. When? Incomplete.
Which call?
On any of the calls.
I'm not a vocal expert. I was given the calls stating that this was the voices of individual people, but I'm not somebody who goes out and does the work to determine that it's someone's voice. I was given information and data, and I reviewed the data, but I can't confirm what the audiologist confirmed.
Okay, so in terms of when, which is a good question, can you even tell this court when the last time anyone, whether it be Kathy Betty or somebody else, interfered with a phone call?
I don't have specific dates in front of me right now, so I can't say anything to that at this point.
Well, it certainly wasn't within the last 24 to 72 hours of Beata taking her life, was it, Doctor?
I don't believe there was a phone call in that period, no.
Because you testified that the substantial factors that led to Beata taking her life occurred within the last 24 to 72 hours, correct?
I commented that many of the factors in the last 24 to 72 hours were additional factors, but the factors have been going on for an extended period.
The impulsive decision was made within 24 to 72 hours, true?
The impulsive decision was probably made right before she killed herself.
Okay, one moment, Your Honor. And just so we're clear, the altruistic act to bring Maya home was to end Maya's separation from her family, true?
False. It's an altruistic surrender act, not an altruistic act.
Sorry, the altruistic surrender act was done by Beata to end Maya's separation from her family, true?
False. I believe that Beata's suicide was an attempt to take out her as a factor in leading to it, but I don't believe it was intentionally to bring Maya home specifically. I believe it was, I need to get Maya home with her family. Therefore, saying that it was the only factor, I believe that she knew that she had completed every defense mechanism that she could do to get her child safe. You don't go to the hospital to get better, you go home to get better.
She committed suicide as the last act to end the separation. That's what you're telling us.
No. I'm telling you that she committed the suicide to rescue her child.
From the separation at the hospital.
From the maltreatment at the hospital.
The ultimate decision was to bring her home.
The decision was to end her life to get her daughter safe.
One moment, Your Honor.
He should not have
safe
gone
at home. True.
Get her daughter safe. She wanted to get her out of the environment that was causing her the pain.
He should not have gone there.
Nothing further, Your Honor.
He should not have gone there. Oh, my goodness.
Nothing further, Your Honor.
Members of the jury, anything further?
He kept angling for the win.
I've got another jury question.
With every move, he was sinking deeper. Another jury question coming in. So lawyers are going to review this one more time. That was this witness. Oh, my goodness.
And mute your microphone.
He stepped in it again. It was a mistake by Shapiro. Now, I wouldn't say it's a mistake. Okay, I think that it was a calculated move where he thought he could get a win out of this doctor's testimony, and clearly for the argument of the defense, if they can say that her goal was to get her home, and then that she had opportunities to get her home but didn't take that, then clearly it wasn't the hospital. She had other. So the testimony was fantastic. The answers were incredible, and even though it came from so many different angles, he still was not able to get that little win. And each time he sought additional clarification, there were additional daggers placed in defense's back. It was that was brutal on the defense. It was. He's kicking himself now. He thought he could.
Okay, doctor. I need to reopen the microphones again.
Let's see what the last question is here.
Can you hear me at this point now?
I can hear you fine. Can you hear me again?
Yes, absolutely. The next question from the jury. Whether it was Kathy Beatty or someone else at the hospital interrupting the phone calls between Beata and Maya, did the interruptions of the phone calls still play a factor in her death?
Absolutely. Yes.
Plaintiffs, anything further?
No, Your Honor.
Defense, anything further?
No, thank you, Your Honor.
May this witness be excused.
Thank you, Your Honor. For now, Judge, but I'll still keep you under subpoena for possible rebuttal.
Okay, so Dr. Richards, at this point in time, you're free to go today, but it's possible that the lawyers might call you back at some point before the trial's over, okay?
And I will be back in Florida for that, Your Honor.
Okay, thank you very much. Have a safe flight back.
Thank you, sir.
Okay. And I'm putting him, so Dr. Richards is out of our, can I see the lawyers for just a moment, please?
And this moment of autumn brought to you by the court and their screensaver. All right. That was, the jury knows the deal. They, seriously, they're angling, saying, wouldn't it be the same? We don't care who it was. If it was somebody at the hospital who did this, we don't care who it is. The hospital's to blame. That's what I get out of the last juror's question. Wow. Oh, man. They're squirming. The last three questions, the predicate question followed by the follow-up from the first round, and then this last question from the jury, just amazing. So now we're discussing.
Okay, members of the jury, we're just talking
lunch.
timing and logistics. It's probably, I know you had your union break last hour. I'm giving you a non-union break. Let's keep it to 10 minutes. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All right. Jurors exit.
Okay, so the last note, the first note they sent to him mentioned a union break. That's why he's referenced that. He's saying you only asked for 10 minutes. And he sort of jokes with them, but at the same time, he's trying to steer them away from the humorous side. He likes to control the amount of humor in the courtroom. I'm sure he's not too happy with
Okay,
some
the
of
jury's out of our
jokes that come from the
presence.
jury.
Everyone can sit down. Why don't we take a 5-minute break ourselves? We'll come back and address your motion, Mr. Hunter. But let's try to keep this to 5 minutes.
Okay, there's a motion for Mr. Hunter. And it's probably something to the effect of this prior witness's testimony, okay, because that motions are typically timely for that reason. So Mr. Hunter introduces a motion most likely to exclude or to strike portions of this last witness. That's going to be my guess. And also my guess would be because his testimony was regarding this was either not consistent with his prior depositions or even his testimony today, because I think he did use the word ultimate today. I was sort of surprised when I heard that come out, but interesting. That is motion for directed verdict. Directed verdict comes right after the plaintiff rests, Jackie. So we should see those today, but I don't think we're there yet. We have one more witness, right? We've got Dr. Richards was our first witness. They added one more. I'm trying to remember who it was. It's not Sainsbury, but I think we've got one more witness before the plaintiff will rest today. I don't know how many witnesses the defense is going to call. I have not looked at that list. Cynthia C. says, hello, RA and everyone. I'm so glad to find your coverage of this case. This group is amazing. Your commentary is wonderful. Thank you, Cynthia. Appreciate you being here. Thanks for your commentary and questions as well. I'm starting to wonder if Anderson came off incompetent at first to help with the David and Goliath optics, and then of them versus defense. Okay, that is a strategy we've seen before. It's like, I'm just the bumbling country lawyer, up against the huge, behemoth of this massive hospital, just trying to fight for a little justice and getting squished. We've seen that before. I don't think Anderson is intentionally trying to look silly. I think he is fighting a huge fight. He's fighting a fight against a very powerful and influential and very very well funded opponent, and so I think he's honestly, I wouldn't say overwhelmed, but I think he has his hands full with what he's doing. Anna, the motion was made at sidebar, so we don't know exactly what it is, but it probably has something to do with this last testimony we've heard, or maybe about the testimony we're about to hear. Cynthia, welcome to the gallery. Thank you so much for becoming a member. Great to have you here. Thank you very much. Make sure you help yourself to the free emojis. We have potentially just moments left to get entered into the competition for a hoodie. Get your guess in. That would be wonderful to see your name on the winners list. It's going to be for a mistrial, says Christiane. What's the basis? Didn't I see the judge walk out the door? Epic exposure. Yes, he walked out the door just for a brief break. I'm watching on Zoom. I'm allowed to watch the Zoom feed, which still is live in the courtroom, so I can see the defense and the plaintiff table, as well as the witness stand and the judge's seat. And so the seat is empty right now. But I'm not allowed to either show that view or play the audio from that view, even though the audio is almost always identical to what we're getting on our live feed. Let's see. Can't wait to see how J. Hatch defends this. They stepped in it, listen to learn. Shapiro just waded in, and it was terrible. It was terrible. He kept on trying to get a little bit of a win, even limiting it down. His questions, it got smaller and smaller and smaller and smaller, and still every time the response was worse and worse for the defense. Christy, you're correct. The total objections, we're guessing how many total objections there will be after both sides finish their case. But the end of the time to submit your objections is going to be this morning when plaintiff is done with their case, when they rest. Or I guess it might be this afternoon, the way things are going. Debbie Long, 5 months. Thankful for you and Mrs. R.A. and all the mods and all our chat peeps. I thank you for 5 wonderful months. Justice for Maya. Thank you, Debbie. Appreciate that. This is an incredible case. I know we normally follow criminal cases, but this civil trial has been just amazing. Let's see how convenient that Kathy Beatty says it's not her voice on the recordings, even though it sounds just like her, and Maya says it's her. I wasn't impressed with Kathy Beatty in her deposition. Marianne Ponce says this witness just made mincemeat out of Shapiro. Yes, he did, but this is not the first time. Mr. Shapiro has run into this before. With he's up against some very experienced and smart witnesses that cannot be led into a trap very easily, and he makes his efforts to, I wouldn't say trap them, but to try to guide them to an answer that would benefit the defense, and it has not been working. It's going to be whoever gets it closest. Whoever gets it closest. Okay, Amber, I see you calling, but I lose my Zoom feed every time you call. Or every time anyone calls. Can you send me something on the a message or something? Just don't want to have to restart it every time. Why do courts not charge witnesses for perjury often? Beach Gal, probably because it's very difficult to catch. It has to be literal, under oath, swearing a statement, sworn statement, and changing of that. And they don't get charged a lot. Usually all we see is that the witness just discounts their testimony, and it goes on. I mean, because you have to be able to prove that they lied, and where it's somebody's belief. Not sure. Maybe we should ask some legal minds. Pull on if Beatty will take the stand. It's going to be in defense's case if she does.
Okay, please be seated.
Not sure. Judge is back. Here we go.
Where's Mr. Anderson?
Our team is grabbing him right now, Your Honor.
Paging Mr. Anderson. Paging Mr. Anderson.
Judge,
Please
I
come
did
to Judge
notice
Carroll's
Ms.
courtroom.
Salisbury in the hallway. I'm just confirming. They told us they're not calling her. I'm just confirming that.
They confirmed it.
Yeah.
Okay, well, Mr. Anderson, we're back.
Sorry,
So,
Judge.
Ms. Perez wanted to confirm, since she saw Ms. Salisbury in the audience, that she is not a witness.
No, in the hallway. I saw her in the.
She was in the hallway, and right now she's not a witness.
Right.
I mean, I'm probably going to bring her back to rebuttal.
Right now.
Well, for now.
But for today, she's not a witness today.
I'm not planning to call her today.
Okay.
We do have other courtrooms going on that, she might actually be here for other
I'm going to
things.
say no, but okay.
Or it might have been my screw up in telling her that I was thinking about using her, but not telling her at the very end that I was not using her. Either way,
But
Either way,
today,
you're
she's not a
paying.
witness.
I don't plan it.
Okay, that's all we need to know, Judge. Thank you.
Mr. Hunter.
Judge, this time, I understand that plaintiffs are about to recall Dr. Corcoran to the stand, and we would, first of all, object to recalling him. But secondly, we would renew our objections to his testimony and any testimony he might offer regarding a standard of care or administrative standard of care with respect to Johns Hopkins Children's Hospital, based on on his competence to do so on the basis we previously argued to the court.
Okay. On the issue of recall, I'm overruling that. On the competence issue under the statute, I'm going to stick with my same ruling as last time.
The other thing I would note, Your Honor, is that
And he's not in the courtroom right this second. Okay.
I'm sorry?
I just want to make sure he wasn't in the courtroom as we were talking about him.
Thank you, Your Honor.
I punted him out.
I already blew that once already. This, as I understand the purpose for which he's being called, has to do with training and supervision of all children's physicians.
Just training.
Just training. Well,
I'm sorry. What am I talking about? Yeah, I think it's supervision. Yeah, it's training. Just the training. Sorry.
What am I talking about?
There's three things.
There's a soundbite.
All right, so now I'm sure it's training.
okay. Judge, the only thing I've been furnished about his training material here has to do with, I guess it's back to count 14 once again, and I would renew our objection to that as well. And the declaration that he has filed regarding this matter after his report makes a number of statements about official government policies and regulatory policies and so-called never events. And just as an advanced preemptive matter, we're going to be objecting to that. So
we're not going to ask him about it.
All right,
Counsel.
Very well.
So there's nothing for me to do?
You've already done it.
Okay. Any other issue we need to address before we?
Yes, I'm sorry. Yes, Judge, I spoke with Mr. Whitney about this. When they played Dr. Newberger, they inadvertently left out, I don't know if I could do math, 16 lines, and they indicated I could just read that in.
Okay.
Or did you just want to play the video clip?
No, I don't want to do that. It's just literally 16 lines, Judge. I'll just read the question and answer if that's all right.
And are we doing that in the plaintiff's case in
Yes,
chief?
that's my understanding, because they left it out.
I mean, if I left stuff out.
We offered to role play again too, but she didn't want that.
I didn't bring the wigs today.
No wigs available.
No.
And so
I'll play both parts.
I did have a thought that I should just get everybody wigs, and one day we just all have wigs as the jury comes out.
we could all be barristers.
They did that down in Miami several years. They had everybody come in robes and wigs and the whole 9 yards. It's a bit much for Miami in August. But
And one further issue is we have sent over an additional line out of Sally Smith's deposition that we're prepared to play it. We could read it. We'd prefer to play it. And we sent that over to defense counsel yesterday.
Judge, we object to that. I mean, first of all, it's something that was previously designated, apparently. They're not saying they forgot to play it. They're saying they're adding a designations, and it comes after a section that puts the comment in context, and they're not playing that section because it has to do with her role of being called in as the investigator. So they want to play this snippet out of context, and the context is not coming in.
Well, I would need to see the deposition plus the context.
Can we play so they've objected to both the singular question, and then when you offer to play the context, they object to having the context. So we're between it. So can we play the clip for the court?
Or do you want us to put Cochran on and do it for
I think of the transcript would be.
I would like to see the transcript so I can read, what happened before. And let's get Dr. Cochran.
All right.
And I can take transcript with me to lunch, and I'll look at it and make an assessment at lunch.
Okay.
Very good. We're ready.
do we know how long this is going to be?
Yeah, just how long Cochran's going to be?
Yeah.
Very brief. He's got 1, 2. I'm not going to go back through background training experience. 1, 2, 3, 4 questions.
Okay.
They're long questions, but
So what we're going to do, we'll do Cochran. We're then going to role play Newberger. We will then take a lunch. I'll decide on the Dr. Smith thing. If we allow it in, you'll do that immediately after lunch, and then you're resting. Is that?
I want to call Jack Kowalski just to confirm that one question about whether he told Beata about the divorce comment from Beatty.
So Jack has been called 4 times
Then we
now.
rest.
So can we do that before we go to lunch?
Sure.
Okay.
Yes.
So
Yes, sir.
do Newberger, then that one.
How many times is that?
I'm sorry, Art, go ahead.
We'll do that one question from Jack Kowalski, take lunch, then we'll make the ruling on Sally Smith, and then you're rested.
Yes.
Okay. Where'd Mr. Whitney go?
I think he was trying to find a witness.
Well, can I bring in the jury while we are
Certainly can.
trying to find the location? Okay.
Okay,
Might
here
be
comes
up to
the
you,
jury.
Miss Lawrence.
Me again, yeah.
The main, both attorneys, Anderson and Whitney, walked out. And so the judge is like, well, Ms. Lawrence, you just passed the bar. You're the only one here. Your case. That's a funny comment.
All rise. Jurors enter.
Yeah, Mark, the judge ruled early on in this case that defense, basically, he says it's their time. If they want to call someone 7 different times, I'm not going to stop them as long as they don't release the
welcome
witness.
back, members of the jury. I want to confirm, while you're away, you did not discuss this case amongst yourselves, you did not do any investigation, and you received no information. Is that all correct? And you did not get approached by anyone about this case. Is that correct? And that you have not seen any media coverage on that last break. Is that correct? Okay, plaintiffs, call your next witness, please.
Plaintiff's call Dr. Joe Corcoran.
Yeah, if Jack had, if the witness they were recalling was somebody that had to travel,
excuse me,
or was, it was very difficult for them to be there. The judge would have a harder time.
I do.
That was awful audio, Mr. Audio Guy. That was terrible. Yeah, you can't waste the doctor's time and all that, but party to the case in the courtroom, not a problem. Hello, doctor.
Please state your name for the record.
Good morning. I'm Dr. Joseph Corcoran.
I was going to say, you remained a doctor over the past 5 days since the last time we asked.
Yes, sir.
Okay. And we'll forego the background training experience. The jury's already heard. Last time we discussed your opinions as to training of staff, and I'd like to ask you a question now regarding training of physicians. So first now, if you could, to remind the jury, what were your concerns in terms of the setup of Johns Hopkins reporting system and the needs that the needs for the enhanced needs for training in that setup?
Objection, Your Honor. All due respect, I don't understand the question.
I think you need to.
I'm asking a lot of those today. Can you tell the jury, based on your investigation, what, if any, training needs arose as a result of the system you described when you last testified?
Objection, foundation.
Overruled.
So, as I proposed last week, there was a lack of system-wide approach to quality assurance and performance improvement. That put, by design, the responsibility for quality assurance and performance improvement at the division level. There were 15 divisions, for instance, that reported up to Dr. Napolitano as the chair of the pediatric department. Okay, so with each division having their own system of quality assurance and performance improvement, it was really incumbent on the chair of the department to make sure that there were no holes in the safety net, as I discussed last week. So, as Maya moved from the emergency department, that's one system, to the pediatric intensive care unit, that's another division and another system, into the wards where she was followed by the hospitalists, that's another division and another system. Each division then needed to have physician champions who were trained to understand quality assurance and performance improvement. So each division had to have somebody who knew the rules, who could separate, here you're between the guardrails, here you're outside of the guardrails. And so the documents that I reviewed, which I provided that list last week, I saw no evidence that that training ever took place, that there was no format for that training to take place. And so you didn't have anyone who was trained to police the activities of their colleagues to make sure that patients like Maya and others were kept safe and that care was delivered between the guardrails of what the data and evidence showed delivered the best results.
So do you have an opinion based upon your background training experience and to a reasonable medical administrative probability as to whether Johns Hopkins breached the duty of reasonable care in its training or lack thereof of physicians in the role you described?
Same objections previously.
Okay, overruled. You can answer that, doctor.
Thank you. Yes, I do have an opinion.
And what is that opinion?
And I do believe that duty was breached because, again, there was no evidence that this training took place. And despite the department chair saying it's not his job to initiate change, I would argue that it's exactly his responsibility to initiate that change, to make sure that there are no gaps in the safety net.
Are you aware that Johns Hopkins was treating for this treatment of CRPS during the admission of Maya Kowalski?
That they were treating for
Excuse me, that they were billing for treatment of CRPS during this period of time?
Yes, I'm aware that they billed for treating CRPS.
And have you had the opportunity to review both the admission and discharge notes where they were denying that diagnosis?
Objection, Your Honor. Foundation and the representation of the record.
Let's rephrase the question.
What, if anything, did the hospital represent outside of the hospital as to whether Maya Kowalski had CRPS?
Objection, Your Honor. I'm not sure what the question is asking or the documentation it's asking about, but the record speaks for itself.
Okay, overruled.
The diagnoses were focused on the behavioral health diagnoses of conversion disorder, Munchausen's by proxy, and it really seemed like CRPS was disregarded or dismissed.
All right. And is it understood in your field that billing for treatment
Scratch all
Is it
that.
understood in your field that billing for treatment will ultimately result in some final financial obligations of the patient or family, even in the event they have health insurance?
Objection, Your Honor. It's compounded. I frankly don't understand it. Outside the scope of his expertise as well.
It seems a little bit far, so I'm going to sustain the objection. All right.
Nick.
Okay.
No further questions.
One moment, Judge.
Okay, Amber is going to post a message here.
Sure.
While they approach and talk over something. Amber has graciously gone out and purchased at her own expense a burner phone to give out to you guys in case there's a problem regarding your entry. If you know that there's a problem and need to make a change or something, Amber has graciously provided this information. I've got it up on the screen now. We're not going to post this a lot of times, so because this contest is about to end. But if you know there's a problem and you need to make a change to it because we're still within the period, contact her that way. You'll need to use your information that you identified your entry with in the entry. We'll try to get it fixed just so everyone gets a good, fair shot at the contest. And we'd like everyone to be in the running for this. So. And Amber, thank you so much. Amber volunteered for this position. She really did. On her day off, she volunteered to do this. All right, we are right near the end. I'm waiting. We still need to hear that few lines of testimony that need to be read in from a deposition. Those 16 lines. I'm not sure if the judge is going to have somebody read it in or not. Maddie, welcome to the channel. Thanks for subscribing. We call that admitting to being an addict. So welcome. You're one of us now. You can never leave. Thank you so much. Let's see. I am trying to find...
Mr. Hunter, you may proceed if you have any questions.
Just a couple now. Morning, Dr.
Good morning, Mr. Hunter.
When did you find out you'd be joining us again?
It was sometime over the weekend.
Oh, okay. So sometime over the weekend, you were called and told that you were needed again, and so you got down here Monday morning.
Yes, sir.
Okay. How much is Mr. Anderson's firm paying you to appear here?
Sir, as I discussed in my deposition, I've never not once discussed compensation as an issue.
I see. So you can decide how much when it's all over and see the results?
Sir, as I told you in my deposition, that's not why I'm doing this.
Okay. Point is, you haven't discussed a fee, and you'll discuss it when it's over.
Well, Mr. Whitney described it as pro bono. I believe that's the legal term for doing this.
So you're a volunteer?
I am, sir.
You're a volunteer who wants to help?
Yes, sir.
Okay. You're not even under subpoena?
I'm sorry?
You're not even under subpoena?
I believe I actually am.
Okay.
Subpoena.
But you came down here on less than 48 hours notice to help out again, right?
Yes, sir.
Okay. Let's talk about what you were given regarding this issue of physician training. Were you given any physician's personnel files?
I don't believe that I don't have my documents today that you took a look at on Wednesday.
Well, I just happen to have it right here. I can look at it.
I don't believe that any physician personnel files are on the list.
Your Honor, please, I'm sorry.
You may proceed.
Thank you, sir.
So you weren't given any physician personnel files. Were you given any physician files regarding their continuing medical education?
Oh, no, sir.
Okay. And those files are commonly kept by hospitals that employ physicians, aren't they?
Of employed physicians, yes, sir.
And they also are kept by medical staff offices regarding physicians who are on medical staff, aren't they?
Certainly around CME, yes, sir.
Okay. So it would have been easy for you, with your experience, to find out what CME these doctors have had, right?
Yes.
You just had to ask.
Can he answer?
Yes. However, the type of training that they would require for understanding their responsibilities would be more at the hospital and division and department level.
Exactly. It would be at what's called the in-service level, wouldn't it?
That's a common term, sure.
Okay. And commonly, when hospitals have in-service education for their staff and for their physicians, they arrange to get CE credit for it, correct?
Sometimes, but not always, no, sir.
But you could find that out by asking, couldn't you?
Well, given that there was no evidence that that was taking place, it would be hard to imagine who I would ask for that information.
But you didn't ask anybody, did you?
Hang on. Can he please be allowed to answer the question?
Mr. Hunter, let him finish the answer.
But again, Mr. Hunter, a lot of that education takes place outside of in-service. For instance, when I talked about improving our performance on sepsis, most of the training that we did with our physician champions that helped us cut that mortality rate nearly in half, that took place in small groups that was not part of continuing education. It was not part of in-service. It was project specific.
But it was also frequently noted in personnel records, wasn't it?
No, sir. Actually, it wasn't.
Well, apparently your hospital doesn't keep very good personnel records. But leaving that issue aside,
I would disagree with that.
Move to strike. Sustained. The jury's going to disregard Mr. Hunter's comment.
I'll leave aside that issue. My apologies, Your Honor, but let me ask this. You've told the jury you didn't have any evidence of that. Did you ask the question?
Not over the weekend, no, sir.
You never asked it, did you?
Not over the weekend, no, sir.
Well, did you ask it before the weekend?
I was asked about this over the weekend, sir, so not over the weekend.
So the first time all this came up was over the weekend? Kind of an afterthought?
Well, again, the review of the documents has been an ongoing part of my involvement in the case, and I just got involved in the spring, not 5 years ago as you were. But the review of the documents began long before then.
Okay. Well, my question to you is, you've told the jury you don't have evidence of certain things. Have you ever asked what evidence existed of the training level of the doctors who were involved in this case? Have you ever asked that question?
Again, sir, I was asked about this specific question over the weekend.
Okay.
No, I did not ask anybody over the weekend.
Okay. You've never had the chance?
I never asked anybody over the weekend.
Were you aware that both the history and physical and the discharge summaries from All Children's Hospital made specific reference
Objection.
in Maya Kowalski case to
Beyond scope based on their objection.
Well, I didn't hear the question, so let me hear the question.
Were you aware that both the H&P, history and physical, the admission document, and the discharge summary for Maya Kowalski in her admission to All Children's Hospital of October 7th made reference to a diagnosis of chronic regional pain syndrome? Did you know that?
Is the objection?
I'm going to sustain the objection.
Okay.
Witness is in there with a smug look on his face. Hunter is still steaming.
Nothing further on.
And
Jury
anything
questions.
further, Mr. Anderson?
Did Mr. Hunter just show you any documents to indicate that there actually were continuing medical education or other indications of the type of training you were talking about?
No, sir, that's not on the one document that he shared.
Anything else, Mr. Hunter?
No, Your Honor.
Members of the jury, do any of you have got a couple of hands?
Got some jury questions coming up. That was some pretty spicy, aggressive cross from Mr. Hunter. We've seen that a little bit in argument before the judge outside of the jury's presence, but I think that's the spiciest they've seen him in court, like the jury's seen him. And I'm not sure if it was a good look. I see what he was getting at, basically saying, so here you are, this friend, you just come down and say whatever they want, he needs you to say. How much are you getting paid for this? Nothing. So that didn't work very well. But then, did you look for information? Wouldn't you look in their personnel files and everything? And it didn't really go anywhere. The truth is the hospital didn't have these training things set up. He already testified to this, basically, and we're just sort of hitting it from a different angle with this recall witness session. But spicy Mr. Hunter, not happy, not very happy. You can tell he didn't like this testimony because of the objections that came prior to him giving it. And now the testimony comes in, and it was pretty aggressive. Okay, we expect now, as soon as the jury questions are over, we expect assuming that we don't have any more questions from plaintiff or defense, we expect this witness to be dismissed, and Mr. Jack, right there, Kowalski, to be called back to the stand to testify about telling Beata about when Beatty suggested to him that he should get a divorce. And then that will pretty much end the testimony we get from the plaintiff's side. That'll be the rest. So get your objection form in now. If you do have any problems, do reach out to Amber. Amber has posted her burner phone number as well as her email, where you can reach out to her and get your entry corrected if you had a problem or you feel there's a problem on that. Baby Bear just gifted 5 memberships. Thank you, Baby Bear, for your generosity. Been a long-time supporter of the channel and sender of delicious food, I might add. She's sent me some great stuff. All right. Let's see. Who was Buffer? Plaintiff's about to rest. Get your objection submission in now. See, I did that before you did it. It was really good. Hunter just shot himself in the foot. He didn't have anything really to gain there. He tried to attack where he could. The witnesses have been able to hold their own in cross, and they just haven't been able to gain any foothold. I want Tom Cruise to come in yelling, "Show me the money!" Beach gal, that's funny. Show me the money. That's I don't think I've ever seen that whole movie, but I've seen that clip. Hunter didn't get the answers he wanted. Shapiro didn't get the answers he wanted before then. I don't think there's going to be very aggressive crossing of Jack on the stand, as he has very limited testimony. So unless they can find somewhere in deposition where Jack said something completely opposite, it'll be very limited. And then I think, honestly, defense is just wants the attack to be over, and then sort of try to pick up the pieces from there. They'd like the plaintiff to rest. Lynn Britton, thanks for your coverage. You and Rob are explaining so well. Rob is the legal mind, for sure. I will explain what I can, but Rob is the professional when it comes to this, so I'd always defer to his expert opinion. Rob, of course, we're talking about is Rob from Law and Lumber, not affiliated with the channel. He's one of the great LawTube channels out there, and just to have a lot of respect for him. Jury question: does Mr. Hunter need a Snickers? Everyone's going to get a lunch here in a little bit. Let's see. Speaking of Rob from Law and Lumber, Lady Draconis, who was, I believe, a mod on Rob's channel, you had asked a question earlier, and I was going to respond to it, and then I forgot. So if you can ask it again, let me know. Something about Rob had a 6-hour live stream because he covered, I think it was 2 days in a row. He had to cancel his Friday night fights so he could cover that, and it just went and went and went. I know it was like 1 o'clock in the morning. I opened up my phone because I'd gone to sleep while listening to it, and it was still on. So it was great. I didn't get to hear the whole thing, obviously, but it does a great job. 6.5 hours on Friday. Whew. That's dedication. I mean, we do a long live stream, but for most of the live stream, I'm not the one talking, right? We've got witnesses talking, we've got argument, we've got the judge. 6 hours of Rob just breaking it all down was impressive. It was a true marathon. Okay, there he is. There's Law and Lumber's channel. If you haven't subscribed to that, I imagine all of you probably have already, but just in case, it's there on Samantha Terry's chat. Thank you, Samantha, for that. Rob was trained after it. He was trained during it at the end. I came near the end, and he was. You could tell it was exhausting to cover all that, and there was so much that happened as well. Rob can make a free trial like watching an exciting sports game. But he doesn't create
There's
drama
only a
with it.
couple of the questions I'm going to be able to ask.
There's just a lot to cover.
Doctor, in your hospitals that you were in charge of, did your committees meet on a monthly or quarterly basis to discuss improvement projects in complex patients or issues happening on the units to keep leadership informed?
So we had a daily huddle with all of the managers and directors, nurses, physical therapists, etc., meet with administration at 9 a.m. every day to discuss problems on the floor. As a quality department, they worked in close quarters. They reported up to me, and I met with them on a weekly basis. Our quality committees generally met monthly because that information was then passed and shared with the medical executive committee and ultimately up to the board. There were some committees that met quarterly, but most of them met at least monthly, if not more frequently.
Can't ask that one or that one. Has Johns Hopkins All Children's Hospital trained their personnel at this time, meaning at the time of Maya Kowalski being at their hospital, on CRPS?
At the time of Maya's hospitalization?
Yes.
My understanding is that there was no expertise in CRPS at the hospital in 2016.
Okay. Plaintiffs, do you have any follow-up questions?
No, Your Honor.
No, Your Honor.
Okay. May this witness now be allowed to leave?
Yes, he may, finally.
Okay. Is he still under subpoena, though?
Yes, in case for rebuttal, Judge.
You're still under subpoena, sir, but you're free to go today.
Thanks very much. Thank you.
And your next witness, Mr. Anderson.
We're going to call Jack Kowalski very briefly, Your Honor. And publishing that one.
Okay, get your guesses in. Get your guesses in, guys. I imagine break here at lunch is going to be rest. Link for the contest is right here. Samantha Terry's comment.
Has Buttercup been in here? She's in a smiling pile of poo load of trouble. My credit card is missing again.
I don't know what you're talking about, Rebecca. Yes, Buttercup's been here.
Please state your name for the record.
Jack Kowalski.
Mr. Kowalski, you've been up here several times. I just have a couple of questions. One is, did you tell Beata about Kathy Beatty's question to you about, have you ever thought of getting a divorce?
I did.
And was that, from what you saw, upsetting to her?
It was upsetting to myself, and yes, it was upsetting to her as well.
Right. And did Beata know through you or any other means, if you know, about the dress issue? That is, the dress bought for Maya that ended up in Kathy Beatty's office rather than given to Maya?
Yes.
When you came home, or even on the drive home from seeing Maya, how did Beata react in terms of trying to get information from you?
A lot of times I would call her, let her know I was on my way home, and she would ask, during that time or when I did get home.
Did you try to the best of your ability to tell her every single thing you heard or saw in that hospital about Maya?
I tried to do as much as possible, yes.
Was there a time when you bumped into Dr. Katzenstein in the hallway, if you recall, and you asked her certain questions?
Your Honor, may I just briefly approach them?
Yes. Yeah, they're going to object here. Hang on, I'm trying to get back in the Zoom. Got booted out. Just one second. Big Mike, just got your message. Send Amber a text. Send Amber a text. Amber, do you want to post it one more time? Yeah, we'll remember what your guess was. Don't worry about that. And we'll do another contest as well. We've got more coming. There's the message. Big Mike, reach out to Amber if you need to make a correction on your guess. Okay, so this might be the last line of questioning for Jack, and then we anticipate the plaintiff resting here and then calling a lunch break, or maybe going to lunch and then resting.
The objection is overruled.
Tell the jury what happened with Dr. Katzenstein.
I don't know a specific date. It is in my notes, I believe. Dr. Kettenstein was out in the hallway, and I said I wanted to see her. She said she knew that I was looking for her, but she was unable to talk to me. She seemed nervous looking around, and she said she was unable to speak.
Objection to hearsay, Your Honor.
Party admission.
It's not an objection. It's not a party admission, Your Honor.
Can I see the attorneys for a second?
Okay. Wow. We've got a last minute bomb drop, mic drop moment that they're trying to fit in. Let's see where this goes. It has to be, because this is clearly hearsay. Okay. What were the testimony that Mr. Anderson's trying to elicit from Mr. Wachowski? Did I say that right? I think so. Is definitely hearsay. It's him saying somebody else said this, and for that to be allowed in, there has to be an exception.
You may proceed, Mr. Anderson.
Yes.
Yes, overruled. You can continue to answer the question.
I'm getting to learn this. She stated that she was unable to speak with me. She would have to speak to both sides' attorneys, my attorney and then the hospital attorneys. She did provide me with her business card at that time.
What, if anything, did she say about risk management?
She stated, I honestly don't know word for word, it's in my notes, but she just basically said she shouldn't be talking to me at that time.
Because?
Because of just, she had to speak with both sides, the attorneys. I honestly don't know exactly how it was said.
No further questions, Your Honor.
Nothing, Your Honor. Thank you very much.
Okay, members of the jury, do you have any questions?
Last chance to ask Jack
Seeing
a
none,
question.
sir, you can go ahead of us.
Thank you.
All right.
Members of the jury, I'm looking at the time.
It's going to be lunch
and
first.
It looks like this is probably a good time for lunch. So let's have the jury ready to go at 1:30. Okay. Enjoy your lunch. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All rise. Jurors exit.
So I'm trying to remember the person they're talking about in the last question to Jack. Was that about, was that someone from risk management talking to him? It's a long lunch, but we've got some work to do on this lunch period. It might be on the front end or the back end. I'm not sure which one.
Okay. Please be seated, everybody. Okay, I've received the deposition of Sally Smith. I will be looking at that over lunch, and we'll be ready to go on that. Oh, I forgot to do the Dr. Newberger.
Since you're doing another dep after lunch, I think it'll fit in, Judge. We'll just do that.
Okay, I apologize.
That's right.
That slipped my mind. So we'll do Dr. Newberger and then maybe Dr. Smith, depending on how I come out on it. And then you all are resting, correct?
That's correct.
Okay. Just want to, if you want to talk to the clerk and make sure you have all of your exhibits, go ahead and do that. But please be sensitive that they need to have lunch as well.
I have a very easy ruling for Your Honor. On deposition designations, the plaintiff designates, the defense designates, and there's some that are both designated by both parties. Is it the court's decision that dual designations are split 50-50?
Exactly.
Thank you, Your Honor.
Anything else before we go on lunch?
I don't know that we've been observing that in our case.
We have.
That's a new suggestion at this point.
It's not. I don't think it's new, Judge. I think that's the way it's been. And whenever Clay's given time, that's the way he's done it. So I actually don't think there was a lot of green in those other depths, but if you want to revisit it.
Okay. Well, we're not doing it right this second.
Okay.
Let's put it that way.
They're trying to
If we are
use up
back
the
at,
plaintiff's time.
1:15, is that going to give us enough time? I also saw that there's a whole bunch of exhibits that the defense wants in. And I don't know if all of these are supposed to be discussed today, or is this?
I don't know, Judge. They're mostly medical records. We'd like to get the medical records admitted. They objected that we didn't designate certain pages, but they're medical records. We're putting the whole medical record in.
I guess what I'm asking is 15 minutes enough from us coming back from lunch, or do we need 30 minutes and we shave off time of your lunch? That's what I'm asking.
Judge, I think we can take those up tomorrow morning. I mean, this, technically, our case.
I don't know what we want for Dr. Behar, please. Posing or she?
I know, but we're not going to.
Okay, no. Okay.
This afternoon.
Yeah, as soon as we do Newberger and Sally Smith, they're going to stand up and say, I rest. I'm going to turn to you and say, call your next witness, or call your first witness.
And we'll be reading a deposition, or playing a deposition, Judge.
So is 15 minutes enough, or do we need 30 minutes?
15 minutes is enough, Judge.
Okay, then we'll be back here at 1:15.
All rise. Court in recess.
All right, here we go. As we're at lunch right now, so we're going to have a break. The jury's going to be back at 1. They're going to be back at 1:15, so we're going to be back at 1. That gives us an hour and 3 minutes right now, but we're probably going to eat into some of that time. Judges are reviewing a couple depots. We've got Newberger and Dr. Smith. He's reviewing Smith, and either of them, I think they're fairly short, but they're going to be coming in still on the plaintiff's time because it's something that they left out, I believe, initially. So we'll see how that goes. Anything else? Let's see. I'm supposed to report to you for excessive tardiness. Debbie, you are late, but at least you're here. You have to type !late in chat to let everyone know. Anything else we need to cover? It's spicy morning, very spicy, but here we are. First of all, we'll cover the contest, right? Because the contest ends when the plaintiff rests. We will not take any more submissions at that time. So when the plaintiff rests, that's when we stop. As just for your information right now, we've got, looks like 981 objections so far. That we're up to. So that's what the score is. But you're trying to guess how many we're going to have after the defense rests and we have closing statements. So at the end of closing statements, the jury gets the case. That's when we're going to check and find the winner of the contest. And the winner just may find a new hoodie in the mail from us. All right. What's the score, Maisla? That's the score. I think the plaintiff has been winning today. Defense won on a couple exhibits. There were a couple things that the plaintiff wanted to get in. I think the risk management note that had basically the scribbled note that says get rid of the first note in the Maya file now and circled. Underlined and circled, that did not come in. That would have been very interesting for the jury to see. I'd like to have some sort of explanation as to what it was. It may come up later in court as it may be brought up in impeachment or to refresh someone's recollection in the defense case. So even though the judge has ruled that that's not coming in now, it may still come up. It is halftime, Beach Gal. It really is. We're approaching halftime. The band is ready to take the field. Let's see. No, Maisla, that's right. Total throughout. We're talking about right at the end of closing arguments. That's the total, all the total. We're at halftime right now, so we've got 2 more quarters, or at least 1 more half, I guess, to count into that. Jules is in court today. Yes, she is. Let's see. If you've messed up your entry, and I realize we've got like 800 some odd entries in the contest right now. Amber has graciously shared her personal cell phone number. No, just kidding. She has a burner phone where if you made a mistake on it, you have to enter it, but you've got to provide your information to her. It's right here, and she can fix your entry if needed. So, but only if you messed it up. If you guessed low and you're like, I think I want to change my guess, that's not what this is for. We're just trying to fix the ones that were error guesses. But we don't know how many times Mr. Anderson's going to object. The marching band refuses to yield, says Valerie. Valerie, were you in band? I have to admit that the band, people in the bands work so hard at what they do. If you've ever been and watched a band practice, usually it's in the middle of summer, the heat of the summer, out there playing instruments and marching and doing, keeping time and keeping all the choreograph movements down. It's incredible work what they do, and got to watch some bands over the weekend perform at actually I think it was Thursday night at the football game. Jess Rubery, welcome to the gallery. Thank you so much. Good to have you here. Isn't Kiss playing the halftime shows, says Johnny? That would be funny. Let's see. I think we're ready to break. Let's do that. Let's take a full hour lunch. We'll be back at 1:00. So we have 59 minutes left. And then we expect to hear a couple very brief depots, and then the plaintiff is going to rest. And at that point, before they call the first witness, I think we're going to see some motions for a directed verdict coming from the back of the room, from Grandpa, as you guys called him this morning. I like that guy. He's honestly, his legal knowledge is incredible. The depth of his knowledge and understanding of the ramifications of decisions and things like that. It's huge and quite impressive. Even if I'm not a big fan of what he's arguing at the time, very impressive guy. Melissa, yes, my son is in marching band. They work extremely hard. I had a lot of friends in marching band. I was not in marching band because I needed to take more core classes to make up for the ones I had failed. when I was in high school. True confession, I barely graduated, and it was only because of night school and summer school that I did graduate. And then I went to college and did very, very well. I was, I don't know what it was. I just goofed around in high school. It was too much fun. Trish Wheeler, welcome to the gallery as well. Thank you very much. Good to have both you and your new member mate, Jess Rubery, both joining us here at the end of this live stream. We're going to go on lunch. Make sure you click the subscribe button and you've rung the bell so that you'll be notified when we go live again. The first person in chat when we as soon as it opens up, right? So here, this is what I look like in real life. The first person in chat. Wow, now I'm short. You guys, I moved the camera and it made me very short. So now I'll fix it over lunch maybe. Anyway, the first person in chat after we open up the new placeholder for the live stream wins the internet. That's something we do here. We gift the internet every time we go live. I'm slouching, Greeners. I apologize. I stand corrected. I sit corrected in this case. All right, let's go to lunch. We've had enough stalling. I'm hungry. I'm starving. It's time. Want to give a huge shout out to the mods today. Thank you so much. Huge shout out to all of you in this community. It would not be the same without you. This is what I call the best place to watch true crime, and it is because of you. So thank you very much for that. Thanks for your warm welcome of everyone who's come through the door today and previously, as there's just about 40,000 of you that are just really, really amazing people. Thank you so much. Amanda, thank you for continued support there. Month 2 there. Let's see. I think that's it. Internet ownership changes sometimes twice a day. Sorry, I was lowering my volume and I'm expecting the music to get quieter. So grab some lunch. We'll be back here this afternoon and it's going to get spicy again. Some good arguments are going to be made. I think we're going to see some good lawyering happening. That's what I'm holding out for. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about 56 minutes. 56 minutes from now, Maisla, we'll go live again. So be kind to each other, stay safe. We'll see you in a bit. Bye.
What more do you need to see?
Oh, that was terrible. I apologize.
Because he's the guy!
Are we going to address subject matter jurisdiction?